Still have people signing in, but go ahead, start.
All right, everyone. I'd like to get the meeting started. So welcome to the regular meeting of the City of Bethlehem Zoning Board. My name is Pete Schneck, and I'll be serving as your chairman this evening. Serving tonight with me is Dr. Paige Van Wert, Sharon Wiles-Young, Danielle Joseph, and Lucas Walk. Our zoning officer tonight is Mr. David Taylor. Our solicitor tonight is Attorney Eric Schock. And our stenographer tonight is Moira Evans. At this time, if anybody plans on speaking, please stand so we might have your testimony. So anybody that wants to make comment, ask questions, or speak at all, please stand.
Please raise your right hands. You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear or affirm?
I do so swear.
Thank you.
All right. And then at this time, I'll turn it over briefly to Attorney Schock to go over some housekeeping items.
Sure. So the original advertised agenda had 5 matters. 3 of those have been continued. I'm presuming everyone in the room is here for the 2 that remain, but I just want to announce in case you missed the notice or a sign that one of the hearings was continued. So 241 8th Avenue, Zaworski on behalf of ABDA Properties on 8th LLC has been continued to October 22, 2025. Although in each of these instances, if you're here for that and you leave, you should, again, check the docket, check the city's website. But as of now, it has been requested to be continued to October 22. 230-232 West 3rd Street, Church of the Nativity is continued to September 17th, 2025. And 122 East Gep Street, appeal of Michael Cox on behalf of ERE Reserves LLC is continued to September 24, 2025. So if anybody is here for those hearings are not going to be open this evening. And if you are, you can leave. But as I guessed, I think most people were informed and were aware that those were not.
All right. So the first appeal tonight is 312 Hanover Street.
312 Hanover Street, the appeal of Dr. Ishtaq Ali Sarim, but if I said that correctly, on behalf of Hanover Roush LLC, applicant seeks an interpretation that the zoning officer has incorrectly applied zoning ordinance section 1318.02, lot area or yard required, to applicant's proposed site plan. Sections 1306.01A4, 1318.02, 1325.05, and all associated variances, special exceptions, and interpretations.
And Mr. Taylor, am I correct? The applicant has requested only an interpretation of the zoning ordinance and is not seeking a variance from the zoning ordinance.
That is correct.
Okay. And the reason I say that for the benefit of the board and members of the audience, if you are here on that matter, there are different standards applied when someone has an interpretation. Mr. Deschler, are you here for that first one?
Yes, I'm here on behalf of the city.
Okay. And I'll make a statement in that regard just for to help the audience, but either council can feel free to correct me if they think it's inaccurate. But I just want people in the audience to understand it's not a variance, which has 5 criteria, including public health, safety, and welfare. The applicant is asking only that the zoning hearing board give it an interpretation on what the language of the ordinance means and how it applies to their application. So the evidence that is relevant to that determination will be more limited than if they were asking for a variance. Both council agree. Fair statement, because we may have an issue where if there are people who are interested in this, there may be topics that you'd like to talk about that are not relevant to the relief that's being requested and may have been relevant if the applicant had requested a variance. Fair enough? Okay, fair.
Yep.
Okay. We'll cross that bridge when we come to it, but I thought it was good for everyone to kind of start with that baseline.
All right, and real quick before we get started, can you confirm when the property was posted?
The property has been posted on the 18th.
All right, you may proceed.
Yeah, go ahead.
Okay, very good. Good evening. My name is Jim Preston. I am the attorney for the applicant here this evening. Seated next to me is, I have the same problem with the name. We call him Ali. So this is Ali. He's the owner of the entity that owns the property and is here seeking relief this evening. I think as a baseline, again, as Attorney Schock said, we're not here seeking a zoning variance. But for context, we do have a plan. I thought it'd be a good idea just to bring it, put it in front of the board. They can see what we're looking at. Again, we're not seeking site plan approval. We're not seeking any zoning relief in the strict sense of a variance. But it's probably, rather than do this entirely in the abstract, we have a plan. Ali, you're familiar with that plan, are you not?
Yes, I am.
And is that an accurate depiction of what it is? You can unfold that. Is that an accurate depiction of what it is that we're proposing?
Yes, it is.
Okay. If I may, I can hand this up and. You got that?
Is that accurate?
Is that it?
Yes, it is.
No. That's the old plan. That's the
That-
old
that-
plan.
it's
I'm being
okay.
told that is the old plan?
And it will go away.
Hand out the new plan.
Stretch those out and share. Okay.
And will this be applicants one? Okay.
I do not have an objection to this. I just want to inquire, is this the plan that was attached to the application, or is this a new plan?
There was,
Because I think you need to tell us what was submitted.
there was no plan attached to the application.
Let me ask you this way. There was a prior application as well regarding the property. Is this the same plan as that or a different plan?
I think that's been revised.
Okay.
Okay.
I would say it hasn't been substantially revised. It's still a 3-unit townhouse building at the rear of the property, parking in the center of the property, the existing building up near the front. The uses haven't changed. It's going through some review, and there's been some tweaks to it in terms of, I guess, driveway entrances and throats and so forth.
But to be clear, to the extent there was a prior plan, irrelevant now. You're not presenting that. This is what we're going by for this hearing, correct?
Yes.
Okay.
Yes, that's exactly how I see it. Because ultimately, where we're going here is that you'll see that there's been an interpretation as to what's required to put a 3-unit townhouse on this lot. And it centers around what yard areas one is to take into account when determining the eligibility of this site for this use. That's really what this centers around. Just bear with me for 1 second. Okay, I want to put that there.
Doesn't have a what?
A microphone.
Oh.
I don't know if it matters for your.
So what I'm going to do, if I may, I'm going to call as my first witness, Mr. David Taylor.
But Matt, can you see if that mic reaches over to you? Thanks. No.
I don't think it's going to.
Okay.
I don't know.
All right.
I guess I could move my table closer.
Yeah. Why don't we do that? Yeah. You know what, can I ask for our own knowledge, can you raise your hand if you are here because you're interested in this application as opposed to the second one? Okay, so I was right. There are a few people interested in this. Good.
Are you ready to go?
Yep.
Okay.
I hope.
So, Mr. Taylor, you work for the city?
Yes, sir.
In what capacity?
I'm employed as the zoning officer.
And how long have you been employed as the zoning officer?
I took the title last September 1.
So not a year yet.
Correct.
Okay. You're familiar with the property that's the subject of this appeal
I am.
and the proposed development at the property?
I am.
In fact, it's had a little bit of a history, has it not, this property and the attempts to develop it?
Yes.
And so I want to begin by going over my client's recent interactions with you concerning their property at 312 Hanover Street. And I think that initially my client had proposed to there's an existing two-family detached dwelling on the property, is that correct?
That is what's shown on the plan. I have not been in that myself, no. Yes.
Do you have any reason to believe that what's on the site there now is not a
No.
two-family detached dwelling?
No.
And so initially, my client had proposed to modify the existing two-family detached dwelling at the property to include additional dwelling units. Do you recall that?
That was before my time. But I am aware of it, yes.
Okay. And following a sketch plan review by the city, they determined that there were variances needed in order to do that. Were you familiar with that?
I am familiar with that history.
Okay. And one of those variances was for lot width, if you remember.
Yes.
And I think what happens is the current lot as it sits there now with the two-family detached complies with the 60-foot lot width. Is that correct?
Yes.
But by adding additional units, it would convert into some other type of housing. Is that correct?
The current interpretation or
Back then, it was determined that by adding more than the two units that were there, it would convert from a two-family detached into what, a multifamily?
yes, that was the interpretation at that time, yes.
And that would require a 90-foot lot width, which wasn't available.
Yes, that is my understanding.
And I guess at some point, my client had filed a zoning application requesting the variances. A hearing was opened on the application, and but the application was eventually withdrawn prior to the decision on the
Yes.
merits. Is that right?
Yes.
Now, at some point,
If I can interject, I mean,
Pardon?
is that true? I thought that was withdrawn before we got to a hearing.
no, I thought we had a hearing that night when the lights went out.
No, that was on.
Okay.
Excuse me.
Yeah, we can't have anybody in the audience speaking until the appropriate time. Thanks.
I think this hearing was continued tonight from earlier in the summer, but it was the hearing on this matter, the most recent interpretation request.
Mhm.
The prior one, which I think you're talking about now, just the record's clear, never went to a hearing. The city revised its determination, and then you withdrew the appeal.
That was after this one. There was one before that. There's been 3 applications. The first one was for the multifamily dwelling, did not include townhouses. We came here one night, we opened the hearing, there was a thunderstorm and the lights went out. Everybody had their cell phones on. We sat for about 10, 15 minutes maybe, I don't know.
Oh.
Steve Boel was the solicitor. We agreed that we would continue that hearing.
Okay, so, all right, I was not involved at that time. So that's a third initial hearing. Okay.
Yeah, we've been at this for a while.
I
Mike?
I recall the lot width issue was resolved without a hearing, at least, so that was the second application, I suppose, then. Okay,
Okay, so
Sorry about
just to
that.
back up. Initially, we made an application, as Mr. Taylor and I discussed. We did open a hearing, but we eventually withdrew our application without a decision on the merits.
And that application was for multifamily dwelling.
That is correct.
The ruling was the lot width then had to be 90 feet. You sought a variance, the hearing opened, and then you withdrew that ruling.
That is correct.
Okay? All right,
Right.
Fair-
And-
fair
we
enough.
understand.
Okay,
okay.
Then there was a second application that was filed.
Yes.
Okay. I think that following the withdrawal, in fact, I know that following the withdrawal of that first one, my client submitted a new plan for the property, and I believe that you provided a new zoning opinion or a zoning opinion relative to that plan. Do you recall that?
I recall reviewing a plan, I believe, starting around in sometime in November and December of 2024. I don't recall the exact dates.
Okay. And that plan was to construct a 3-unit townhouse building at the property,
Yes.
right? And that's the plan that's on the DS, or substantially similar to the plan that's on the DS now.
Substantially similar.
And the new plan, in the new plan, the proposal was to leave the existing building as is, untouched, and to add a 3-unit townhouse building separate and apart from the existing 2-unit building. Is that right?
Yes.
And to be clear, the minimum lot width for the townhouses would be 60 feet, not the 90 feet required for a multifamily dwelling. Take your time.
I'm showing the ordinance as reading a lot width, a minimum lot width of 20 feet with 3 dwellings, that would be 60 feet.
Okay, so just to make sure I'm characterizing this correctly, the lot width for the plan that's on the DS would be, the required minimum would be 60 feet, is that correct?
I would want to review that. The width would have, it would have to meet the width.
Okay, that's fair enough. We'll move on. Now, you then issued an opinion with respect to that plan. Do you recall that?
I recall issuing the opinion, yes.
And what was your opinion?
I don't have it in front, I don't have it in front of me. I don't recall all the particulars of it. I believe at that time, it was being viewed as a multifamily, it was being viewed as a multifamily property.
Okay, well, let me do this. Can I approach you? Let's take a look at that. Tell me.
Can I ask council to agree on one thing? Because I know it gets confusing. So in the use section, it's identified as a townhouse. When you go to the dimensional ones, we're talking about single-family attached dwelling, correct? Which is in parentheses after the townhouse. I just want to make sure,
that's correct.
correct? Okay, just so the board is aware. You won't find townhouse in the dimensional requirements. It's a single-family attached with an A dwelling.
Recognize that, Mr. Taylor?
I do,
Does that help to refresh your recollection as to what your opinion might have been?
as I read it, yes.
I'm going to ask that it be marked as, we were up to A2.
Do we have that? Thanks. We have the April one.
So, Mr. Taylor, with the help of A2, can you tell us what your zoning opinion was with respect to that plan?
The opinion was that the property was hosting a two-family dwelling, an existing two-family dwelling, and there was a proposed 3 townhouses to be developed in the rear.
And what was your opinion? Was it permitted, not permitted? Tell us what you found. I believe it's laid out there.
It states that the subject of the variance that was being referred to was no longer required under this interpretation.
So initially, when you received the application, you opined that it was actually a multifamily use of the property. Is that correct?
That is how the Planning and Zoning Bureau was looking at it at that time.
And so we would need a variance, right? Is that correct?
Yes,
What type of variance would we need?
you would have needed a use variance. Or no, my recollection is you would have needed dimensional variance for lot width.
Because the use, in your opinion, was a multifamily use. Is that correct?
Yes,
And in fact, we appealed that decision to the zoning hearing board, didn't we?
I remember zoning hearing board, a variance was filed, yes.
Okay, and it was scheduled for a hearing.
Yes,
In fact, we were almost at the hearing
yes.
when I think something happened where you reversed your opinion. Is that correct?
Sir, I dispatched this letter.
Pardon?
I dispatched this letter.
Okay. And that letter reversed your prior decision, isn't that correct?
To my recollection, yes.
Okay, and we're at the point then where you made a new you determined that the zoning relief was no longer necessary.
Based on this letter, yes.
Okay, well, you wrote the letter. So the
Yes,
answer is
I don't recall the subject, I don't recall the specific request of that previous application.
Okay, but as of that time, then, after review by the city, no zoning relief was required.
Yes,
And I believe it was probably about a month later. Right?
can I clarify?
Yeah.
I didn't say, and the letter does not say no zoning relief was required. The letter said that, the letter upon my reading states that the subject of that variance application has been rendered moot by the current interpretation.
And what was the current interpretation?
That there was an existing two-family dwelling up front and that we're proposing to construct townhouses.
That was your interpretation?
At the time I wrote this letter, upon further review, the city now concurs with your requested interpretation. The proposed buildings are townhouses, subject to zoning requirements for townhouses in the RT district under section 1306-01A4 of the zoning ordinance.
So that did away with the need for a zoning application to challenge your prior opinion that it was in fact some multifamily housing development. Is that right?
Yes,
So now we've got rise at the point where we now have townhouses in the back and the two-family detached dwelling in the front. Is
yes,
that correct? Just at this point, there's no disputing that.
yes.
And then I believe about a month later, you came up with a new idea. Is that right?
I don't recall it.
Well, didn't you send out a letter? I believe dated April 21st, 2025, saying that upon further review, you have another opinion, something to that effect?
Upon further review, looking at the looking at the proposal under the new interpretation that you had a two-family dwelling up front and townhouses in the rear, we re-reviewed that under the requirements of the zoning ordinance.
That was the same plan that you gave the prior opinion on. Plan hadn't changed, your opinion had.
Yes,
Okay, I just want to be clear. So now you're reviewing the same plan, and then a month later, we get another opinion on that same plan, which has been sitting with the zoning office now for, not really sure how long, certainly more than a month. And now you have a new way to think about the use of the property. Is that correct?
once the determination had been made that it was the two-family dwellings up front and that the proposed townhouses in the rear, we re-looked at and re-reviewed the sketch plan through that lens.
Okay. And having re-reviewed it or re-looked at it through that lens, what did you determine?
Determined that now there was two proposed principal uses on the property, and that each was required to meet the requirements of the zoning ordinance.
Well, let's stop there for a minute. You said two principal uses on the same property.
Yes,
That's in fact what this is. Is it not? Two principal uses on the same property? That's what this is.
that is what is being proposed, yes.
Okay, and there's no prohibition against that in the city of Bethlehem, is there?
Under the current interpretation, no. No, there is no prohibition against
There's no prohibition on that. In fact, it's not uncommon in the city of Bethlehem to have more than a single principal use on any given property.
I don't know. I don't have a large enough sample size to say that.
Okay? So you then issued another zoning opinion, and this zoning opinion now claimed that this proposal did not meet the lot area and yard requirements of the city of Bethlehem zoning ordinance. Is that correct?
May I just object? If the witness is being questioned on a document, which he is, it's attached to the application, can we show the witness the document? Does he have it in front of him?
Yeah, we do have it. The April 21, 2025 letter is in the packet. That's what you're
part of the
referring to
application.
now. Yeah,
Yeah, it's in the zoning application.
Okay.
I would assume, I'm assuming he has it, so.
Yeah.
I guess I should inquire, does the board have a copy of the application?
yeah, we have the
Thank
April 21, and then I think it's marked A6, but you said it was A2. We'll make it A2, was the March 20 previous one.
Yep, the previous one.
We're on to April 21. That was part of the app.
So now we're on to the appeal that's currently in front of the board. And that centers around the April 21st letter. And you do have that in front of you, Mr. Taylor? If not, I can give you a copy.
I do.
You do have that. So that says that, in your opinion, that you have, let's see, you've revisited the 312 Hanover sketch plan. Is that correct?
Yes, we re-reviewed it under the lens of the new interpretation.
Okay, and now as the city has further reviewed the sketch plan and fully considered the dimensional requirements, I think you conclude by saying we're out of compliance with the lot area and yard requirements. Is that correct?
Per section 1318.02.
Okay, let's take a look at that. 1318.02. Do you have that in front of you?
I do.
Does the board have copies of that? Okay,
Does everyone have the ordinance? Yeah, we all have it in front of us. So
because I can provide copies if it's
Yeah.
easier. So ordinance section 1318.02 is titled lot area or yard required. Is that correct?
Yes,
And if I understand your letter, you are incorporating by reference the dimensional requirements of Article 1306.
Yes,
maybe I'm going a little too fast. So there's an Article 1306 in the ordinance.
yes,
Article 1306 contains dimensional criteria for the permitted uses,
yes,
both residential and commercial. Is that correct?
yes,
So Article 1306, for example, in the rural residential zone, it has a minimum tract size. Is that correct?
yes,
A minimum lot area per dwelling unit, correct?
yes,
It also has a minimum width.
yes,
So that's where all those dimensions are contained. Is that correct?
yes.
They're not necessarily contained in 131802. Is that right? If I looked at 131802, I wouldn't see those numbers.
You would not see those numbers in 131802, correct?
So back to my question then, 131802 incorporates by reference Article 1306. Is that right?
Yes,
So in order to know if you have compliance with 131802, you need to take a look at Article 1306. Is that right?
yes,
Well, 131802 begins by saying that the lot area and yards required for any new building or use shall not include any part of a lot that is required by any other building or use to comply with the requirements of this ordinance. Did I read that correctly?
yes,
And I don't want to put words in your mouth, but I think that what you're saying is that if you go back or over to Article 1306, which has the dimensional requirements, right?
yes,
And you have to go down to 1306, subpart A, and all the way down to subpart 4 of that to get to RT, right?
yes,
And the reason we go to RT is because that's the zoning district that the property's in. Is that correct?
yes,
And once I get there, I see, first of all, I see in a listing for a two-family detached dwelling. Is that correct?
yes,
And that's the home that currently exists.
yes,
So if I read across, I see that there is a minimum tract size of 6,000,
yes,
minimum lot area per dwelling unit of 3,000.
yes,
And then there's some other criteria in there having to do with yards and so forth.
yes,
If I keep going down in that same block, I get to something called a single-family attached dwelling. You see that?
yes,
That's the townhomes we're talking about.
yes,
That's what Attorney Schock had mentioned earlier. There's some
yes,
not ambiguous, but they use different labels to describe the same thing.
correct, yes,
So that's where I would go to see the requirements for townhomes. Is that correct?
correct,
So now that I'm there, let's take a look. Minimum tract size is 9,000,
yes,
and I see lot area per dwelling unit, 2,200. Is that correct?
yes,
If I understand your decision or your opinion, you're saying that the first sentence of Article 1318.02, which talks about the lot area and yards, right,
yes,
is referring to tract size from Article 1306 sub 4, sub A4, right?
yes,
As well as lot area per dwelling unit, right?
yes,
I'm just trying to get at my understanding of what you're saying here. So as you explained below, you are saying that the minimum tract size for a townhouse is 9,000 square feet. The minimum tract size for the existing building is 6,000 square feet.
yes,
And I have to add those up to get to the total required tract size for the uses that we're proposing. That's really the essence of your opinion?
yes,
Okay. And if I told you that there was another way to view that these are minimum thresholds, so that if you had a 9,000 square foot lot or tract, you could put in any of these uses by itself, other than the two-family, which is the 12,000. Which one is that? Is that the multifamily dwelling?
1,200 or the 12,
I'm sorry, there's a 12,000 there. Do you see that? Track size, 12,000 square feet.
That would be the two-family semi-detached dwelling.
Okay, so if I had 9,000 square foot lot, I could put in any of these uses other than that one.
I'm sorry, I missed the first.
If I had a 9,000 square foot lot, tract area, right? I would qualify for any of these uses, but for the two-family semi-detached, because that requires 12,000.
Assuming there was no other use on the lot.
Exactly. So just for the single use, that's correct. And now it's your position that the words lot area and yards in 1318 refers not only to column 2, lot area per dwelling unit, but it also includes tract size.
Yes,
So we need all of that
yes,
cumulatively.
yes.
You have to add it all up. Okay. Now, can you identify for me any examples where the city has applied Article 1306 in the way that you're suggesting?
The 122 East Gep Street. And I believe 241 East Market Street,
What was the second one?
241 East Market Street, if I'm recalling from memory at the moment. And the other one, which I believe it's a 1225 Eaton Avenue.
So it's your testimony now that in each of those cases, the city added both the tract and the units per dwelling unit to get a total gross area?
We added the required tract area together to get a gross area, yes.
Now, the okay, hold on one second. Okay, so, and just to be clear then, it's your testimony that the city of Bethlehem, per that section, believes that lot area, the lot area referred in section 1302, 1318.02, refers to not only the lot area per dwelling unit, but also the tract size, and you have to add those up. And you have to then be under, when you do all that, you have to be under what? The tract size?
Would have to be under the gross tract size calculated, yes.
Even adding the lot areas per dwelling unit.
I'm not sure I understand the question. They're separate columns.
Right. That's,
I would object on this ground. The lot area per dwelling unit is not a subject of this interpretation, nor was it a subject of Mr. Taylor's letter. Tract size is at issue, absolutely, but not the lot area per dwelling unit.
Right, let's double check it, because I don't disagree. I was getting confused by the introduction of that, because I thought the issue was if you took the requirement for the existing dwelling, the lot area in there, tract size. Took the tract
Well,
size,
I think.
you added the tract size. That's what the issue is. Are you saying that he is adding in the lot area per dwelling unit?
I'm trying to figure out what they're doing. I'm pretty sure I know what the city does just by response. We will have a witness that will introduce land development plans approved by the city where they don't do what Mr. Taylor says they do. And I want to caution here, we need to be careful because we're throwing these words around. 131802 talks about lot area or yard required. So that would be, as it says, the lot area and yards required for any new building or use. I think we need to focus on that because this section 1306 does have a column called lot area, and it's lot area per dwelling unit. And that is what the city has always used to calculate the permitted size of the lot. They have never, ever added tract area to that. They don't do it. And I
Well-
think that the plain language of 13-1802 is consistent with that.
I
So-
just- If I may respond, the concept of lot area per dwelling unit doesn't even, it can't factor into 1318.02. It doesn't make sense, given the language of 1318.02. I don't see how it's relevant just as a concept or relevant as to the practicalities of this case. That, because it's not an issue. The issue is whether there's enough overall tract size to accommodate the two uses. I don't see how lot area per dwelling unit is even relevant to any kind of analysis of 1318.02. I mean, of course it's not. It's not affected in any
Well,
way.
I guess the question would be, shouldn't the zoning officer answer the question as to whether this has anything to do with lot area per dwelling unit? I mean, it's his letter, right?
In the context of the April letter, yeah.
Right. I think that's a simple answer.
Fair question.
Because if he said, I actually do use that, let me show you how, then it would be because the applicant has appealed this letter, right? I guess, fair enough. Can we ask Mr. Taylor?
That's where we're
Does
going.
lot area per dwelling unit have any factor in your determination on April 21?
Not per this letter. I was looking at the overall lot area first.
But
Tract
what's
area.
referred to as tract area in
Yes.
the table.
Tract
That's what you're-
size.
Yes, tract
Yeah.
size.
Tract size.
Yeah.
And so just to be clear, for the record, you determined, do you know what the tract size is of the property that's here now?
I don't have it in front of me. My recollection is it's 11,000.
Tract size, what's our tract?
13,000.
We can't have people
Yeah.
from the audience.
Yeah. We're going to get stricter if it happens again. Please, we can't have people speak out. There will be an opportunity to speak at the appropriate time. But for the sake of moving this forward, when it's Mr. Preston's
I
turn,
wouldn't
Yeah.
expect Mr. Chair to have memorized that number.
Yeah.
I don't know it either. So it's 13,400 and some.
408.
Yep. There you go. Does that sound about right?
That sounds about correct, yes.
That's what's on the plan too.
So it's your opinion then that what the applicant, where the defect is that for the two-family detached that exists there now, there's a minimum tract size of 6,000, correct?
Correct.
And for the proposed single-family attached dwelling, there is a minimum tract size of 9,000,
Correct. Yes.
and that the applicant needs to provide at a minimum the sum of both of those numbers. So they need to provide the 15,000
Overall tract size.
overall tract size. That's how you read this chart.
Yes.
Right. And it's your opinion the cities always apply it that way. If you know, I'm not,
I can't speak to, again, I took over the position about a year ago. I can't necessarily speak to how
You-
they've
you
always
don't know.
applied it. But
you don't know. Is that
correct.
a fair answer?
I'm not positive how they applied it.
Well, if you know, give me an example. If you don't know, just say you don't know.
I don't know how they applied it previously.
Okay. Now, the building that's up front, this would be that two-family detached building up front. Do you know when that building was constructed?
I do not.
Would you be surprised if I told you in the late 1800s?
No.
Objection. Speculation.
No, not would he be surprised is not speculation.
It would be, we
Yes,
have
it
no,
is.
yeah. So the board will take note. Mr. Taylor wouldn't be surprised, but we'd have no idea whether it was built in the 1800s.
You will shortly. You'll have that
I
shortly.
presume-
It may well be. but
It may
just-
well
You'll
be,
have that shortly.
but that was only for the purpose of Mr. Taylor not being surprised.
Yes, exactly. So would that change your opinion at all?
In regards to,
The building that's there now predating the ordinance or any ordinance in the city of Bethlehem such that there was no lot area required for that building or minimum tract area required for that building. Does that change your opinion at all?
In relation to this letter, no, I don't.
That's fine. I got your position now. So your position is we need to add up the sum of the tract areas. When we do that for the uses that are there and proposed, we exceed what you believe to be the allowance, the correct allowance. Is that correct?
Yes.
And as we sit here tonight, you cannot provide any examples of how the city has applied your methodology. You're just not familiar with that, given that you've been here.
Objection asked
for
and
the
answered. He said he could.
Yeah, I thought he gave 3 addresses.
Yes.
Am I getting confused?
I just asked him a minute ago and he said he didn't know.
No, hold on. Let's be clear. I think you asked him if how the city did it historically,
Yes.
right? And he said, I don't know.
That's
But
correct.
before, I thought you asked him, can you tell us of any examples? And you gave us 3 addresses. If those
And
3
that-
addresses aren't that, then we need to clarify. I'm
Certainly.
getting
And
confused.
then maybe I misunderstood the answer. And those are 3 addresses where they added up tract sizes?
Those are three additional addresses where I applied that methodology to
Okay.
reviews.
Very good. I have no further questions.
Okay.
Mr. Taylor, as a zoning officer, can you just go over your duties?
Reviewing zoning permits, and answering inquiries by citizens and developers, reviewing sketch plans, and providing zoning interpretations.
And we're here tonight on a zoning interpretation, correct?
Yes.
Now, you testified you are familiar with the property at 312 Hanover Street in Bethlehem.
Yes.
That's in the RT zone.
Yes.
Now, with respect to some of the prior developments regarding this parcel, and I have some exhibit packets I'd like to pass up to the board members if that would be okay.
Yeah, you show one to Jim first, please.
I have a spare for him.
Yeah. In case he has
Thank you.
the issue.
It's the raised sticker. Here's the chair, right?
Mhm.
Everyone here aspires to the raised sticker.
On the end. So, all right, Mr. Taylor. I'd like you to first look at what we have marked as City Exhibit 1. This is a zoning application also for the 312 Hanover Street property dated February 26, 2025. Do you see that?
I do.
And I think there was some mention about this, although it wasn't presented to you during your testimony previously. But if we can look at the 4th overall page of the exhibit. And that appears to be an email from you to, among other people, Mr. Preston, correct?
Yes.
And it reads, "Good afternoon. Following up to Craig's email below, further review and discussion of the reference sketch plan, it has been determined that the required lot width, 90 feet, for multifamily dwelling in the RT high-density zoning district is applicable for the most recent proposal, as well as those comments covered in the original sketch review in Craig Pfeiffer's email below. Consequently, a variance from the requirements of ZO section 1306.01A4 will be required as well." Did I read that correctly?
Yes.
And the context of this, and this is not the application that we're here on tonight, correct?
Correct.
So as I understand it, this is sort of, I think there were 3 applications referenced before. This is the middle zoning application for this property, right? The second one?
Yes.
And what, and at the time of this February 14th, 2025 email, we go to the next page of the exhibit, were you familiar with and presented with the sketch plan that's the next page of the exhibit?
Yes,
And so at that time, so we're in February of this year, this was at least the sketch plan presented by the property owner for 312 Hanover, correct?
yes,
And that plan included the existing two-family detached dwelling, correct?
yes,
And proposed to be built 3 townhome units, right?
yes.
So, and do you have the zoning ordinance in front of you?
I do.
If we can go to the definitional section, and all the board members have their own packet. I have excerpts if you need any, but you have your own ordinance.
Yeah, we all have our
I don't
own.
need to do that. Okay. All right. So, Mr. Taylor, if we can look at section 1302.40, that's the definition of dwelling overall. Let me know when you're there.
Yes, I'm there.
So the overall definition of dwelling is a building used as a residence, correct?
Yes,
And the definition of two-family detached dwelling is a detached building occupied by 2 dwelling units which are not completely separated from each other by a vertical party wall, correct?
yes,
I guess an example of that would be a 2-story residence with a unit on the first floor and a unit on the second floor, correct?
correct.
And if we look at the sketch plan that's in City Exhibit 1, the two-family detached dwelling, that is the building marked existing to remain fronting along Hanover Street, correct?
Yes,
And if we go back to the definitions in 1302.40, and I just read subsection D for two-family detached dwelling, if we read the definition at subsection B, townhouse, also known as a single-family attached dwelling or row house, it reads, a set of 3 or more attached dwelling units which are completely separated from each other by 1 or 2 vertical party walls. Did I read that correctly?
yes,
And the 3 units at the rear, closer to Rouse Street, is that a set of 3 townhomes?
that was, yes, based on the information given me, yes,
And that was the proposed new construction, correct?
yes,
So those 3 townhomes there are 3 units, correct?
yes,
And they are intended to be completely separated from each other by party walls, right?
yes,
Now, there's also a definition in 1302.40 for multifamily dwelling or apartment, which reads, and that's in subsection F, a building including 3 or more dwelling units other than townhouses, correct?
yes,
And in the zoning ordinance at section 1302.16, we have a definition of building. That definition is a structure constructed or erected on the ground with a roof supported by columns or walls. Structures divided by unpierced masonry division walls extending from the ground to the roof shall be deemed to be separate buildings. See also dwellings. Did I read that correctly?
yes,
And the unpierced masonry division walls, are they akin to party walls?
yes,
So we've looked at the definitions now of townhouse, of two-family detached dwelling, and multifamily dwelling or apartment, right?
yes,
So the building that's identified as a two-family detached dwelling, is that a multifamily dwelling building?
no,
And the set of 3 townhomes, is that a multifamily dwelling building?
no,
Because the definition of the definition of multifamily dwelling excludes townhomes, right?
correct,
So now, so neither of these buildings or set of buildings, because I guess the townhomes are each an individual building, correct? They're separated by party walls.
correct,
In essence, there are 4 buildings proposed and existing on the property, right?
correct,
3 buildings are townhomes, right?
correct,
And 1 is the two-family detached dwelling, correct?
correct,
But none of these are multifamily dwellings, right?
correct,
So going back to City Exhibit 1, we just looked at your interpretation there, right? The February 14th, 2025 email.
Yes,
And it was your interpretation that the use on this property was a multifamily use, correct?
correct.
Now, was that applied to the individual buildings or to the property as a whole?
It was applied to the property as a whole.
And was there any historical basis for, I mean, in essence, you were applying a multifamily designation to a property with buildings, none of which were multifamily dwellings, correct?
Correct.
Why did you do that?
It did that because at the time, Darlene Heller, the former planning and zoning director, said that is historically how the city had looked at these.
How long had Ms. Heller been the city's director of planning and zoning?
To the best of my knowledge, approximately 20 plus or minus years.
And did she convey to you that this was the way the city had looked at these properties historically?
Yes,
In essence, where you had multiple uses on the property.
I'm going to object if you're just going to tell us what Darlene Heller said. Darlene Heller's not here.
Well, I'm just asking what his historical understanding of.
No, you're asking me to tell you what Darlene Heller said.
I wasn't going to say that at all. I was just asking what his understanding was of the historical treatment of properties like this.
Okay.
Mr. Taylor, was it your understanding that if you had multiple residential uses on a property where they added up to 3 or more dwelling units, you would just treat those as a multifamily dwelling,
yes,
even if the individual units, even if none of them were multifamily dwellings?
correct.
And on the last page of the City Exhibit 1, there's a narrative, and this is again part of the, that I guess I'll call it the second application for the property. Narrative dated February 26, 2025, authored by Mr. Preston. And it reads, the appellant intends to construct a 3-unit townhome building on an existing lot in the city's RT zoning district. See ZO section 1302.39B. Appellant seeks determination that the proposed buildings are townhouses, subject to the zoning regulations governing the construction of townhouses in an RT zone, which requirements do not require a 90-foot lot width as determined by the city zoning officer. See zoning officer's email attached here too. See zoning ordinance section 1302.39 B and F. That's what it says, correct?
Yes,
I think Mr. Preston went over this in his direct examination, that if the multifamily designation applied, the lot would need a 90-foot lot width, a minimum lot width, right?
yes,
And I think for a townhome use, it's as low as 20 feet, correct?
per unit, yes.
So you looked at Mr. Preston's appeal, including the narrative. Did that cause you to change your determination as reflected in the February 14th, 2025 email?
Yes,
In essence, did you come to agree with Mr. Preston?
yes,
So he won. He got the relief he was looking for, right?
yes.
Now, did Mr. Preston's appeal or the applicant's appeal, did it seek any other relief than an interpretation that the proposed buildings are townhouses?
No,
And he got that interpretation, right?
yes,
We said they're townhouses, right?
yes,
Not multifamily dwellings.
yes,
And just for the record, there'll be some duplicates, I understand, but City Exhibit 2 is simply a clearer version of the sketch plan that is included in City Exhibit 1, which is the February 2025 zoning application.
yes.
Is that correct, Mr. Taylor?
That is correct.
And on City Exhibit 2, I know it's tough to read, but I think it says for the minimum tract size, and this is what the applicant listed, correct? Yes,
Yes,
it says required duplex 6,000 square feet, right?
correct.
Required townhouse 9,000 square feet, correct?
Correct.
And it gives the existing lot size as 13,408 square feet, correct?
Yes,
I'm sorry, well, the existing tract size is 13,408 square feet, correct?
yes.
Mr. Taylor, I know you haven't, well, have you been to the property?
I have driven past it. I've never walked it.
All I'm asking for right now. So if you look at City Exhibit 3, you have that in front of you?
Yes,
This is a 2-page exhibit. The first page, do you recognize this is a photograph? You know what this photograph is of?
it is of the street frontage of 312 Hanover Street.
And which building is 312 Hanover?
In the photograph, it is the building on the right.
And the building that we're looking at, the existing building, obviously, this is the 2-family detached dwelling,
Referenced on the plan, yes.
and it's detached from the building to the left because we see a gap there between the buildings, right?
Yes,
And this is a fair and accurate depiction of the front of 312 Hanover.
yes,
And we see this from Hanover Street, correct?
yes.
Now, going to the second page of the exhibit, is this an aerial view of the subject property?
Yes,
And does the property at 312 Hanover extend from Hanover all the way to Roush Street in the back?
yes,
And so is the 2-family detached dwelling indicated on the second page in this aerial photograph by a red dot?
yes,
And the proposed 3 townhomes are to be constructed somewhere in the grassy area to the rear?
yes,
And does that fairly accurately depict the overhead view of the property?
yes.
Now, Mr. Taylor, if we look next at City Exhibit 4, this is a printout from the Lehigh County property records. And have you seen this before?
Yes,
And just if you can turn to the third page of that exhibit.
okay,
Again, it indicates the property at 312 Hanover Street, Bethlehem, PA 18018. That's the address, correct?
correct?
And the owner is Hanover Roush LLC, correct?
Yes,
And we have some dimensions indicated here as 60 feet by 224 feet. You see that?
yes,
I think 60 feet is the lot width that's been spoken about, correct?
yes,
And for the land use, there's a reference to residential conversion to apartments. See that?
yes,
Is that consistent with the existing 2-family detached dwelling?
yes,
And the zoning is indicated as being in the RT district.
yes,
And if you can, oh, maybe one more question on that. I know this is different from the lot area on the applicant's plan, but there's a lot square footage there of 13,440 square feet.
yes.
And I'm gonna beat Mr. Preston to it on the next page. There's a year built.
I have
See
my
that,
tab, I have my tab on there.
I do.
Mr. Taylor, okay. When was it built?
1880.
And that's obviously the existing 2-family detached dwelling, correct?
Yes.
And that's the only structure on the property, right?
Excuse me?
It's the only structure on the property.
Yes.
So if we can turn to City Exhibit 5, this is a letter dated March 20th, 2025, from you to Mr. Preston, correct?
Yes.
And was this emailed to him as indicated?
Yes.
What occasioned you to draft and send this letter to Mr. Preston?
Well, it was, excuse me. It was re-looking at the proposed sketch plan through the lens of it being in townhouses and the two-family dwelling.
We've already gone over how Mr. Preston was correct in his requested interpretation, right?
Yes,
He was correct, the city was wrong, right?
yes,
And does this letter reflect that determination?
yes.
Now, Mr. Taylor, the next exhibit in your packet, City Exhibit 6, this is a zoning decision dated from the Zoning Hearing Board, dated December 6th, 2019. An appeal of Van Buren Development LLC regarding lots on Van Buren Street on the city's south side, correct?
Correct.
And I just, I want to talk about this briefly. We've talked before about how there were situations where if you had multiple types of residential uses on the same property and they added up to 3 or more dwelling units, the city would consider that a multifamily use, right?
Correct.
Does this zoning hearing board decision, that's City Exhibit 6, does this reflect a similar approach?
It does.
And just, have you read this decision?
I have.
And I know it speaks for itself, but was there an issue there regarding 5 townhomes on what is identified in the decision as Lot A?
Yes.
And for the benefit of the members of the zoning hearing board, if you can turn to page 5 of that decision. There's a reference in paragraph 13 to applicant proposes to construct 5 units on Lot A and a 2-family dwelling on Lot B. You see that, Mr. Taylor?
Yes.
These units on Lot A, what was the nature of the unit? What type of use?
At the time, it was called multifamily, but the buildings met townhouse.
How many? And there were 5 townhomes.
Yes.
So it was just a single townhome use, but there were 5 units.
Yes.
And the city at the time was still characterizing that as a multifamily use.
Yes.
And if you look on going back on page 3 of that exhibit, there's a section for nature of relief sought. You see that?
Yes.
And it says applicants sought the following relief for Lot A use variance to construct a multifamily dwelling on a lot fronting onto an alley. Do you see that? Is
Yes.
that what it says?
Yes.
Now, those 5 townhomes that were referenced in this decision, was the city considering them to be a multifamily use?
Yes.
Is that why they needed a variance?
Yes.
And in fact, the zoning hearing board addressed this on page 7 at the bottom. Right. It says, while the dwelling units being constructed on Lot A are multiple, in quotes, units, the board believes by definition in the zoning ordinance, the dwellings are better characterized as townhouses. A multifamily dwelling is a building including 3 or more dwelling units other than townhomes. Townhouses are a set of 3 or more attached dwelling units which are completely separated from each other by 1 or 2 vertical party walls. Each dwelling unit on Lot A will be separated by a party wall. Therefore, the dwelling units are townhouses. Accordingly, applicant does not require a use variance to construct a multifamily dwelling on a lot fronting onto an alley, nor does it need the dimensional variance to eliminate the required setback between the off-street parking spaces and the multifamily dwelling. That's what it says, correct?
Correct.
So even back then, the zoning hearing board was sort of saying at the time, city, this multifamily interpretation, it's just not passing muster, right?
Yes.
All right. So the next exhibit in the packet, City Exhibit 7, this is a letter dated April 21st, 2025, from you to James Preston, correct?
Yes.
Now, Mr. Preston talked about this on his direct examination a bit, but after the city came out with its revised interpretation, agreeing with Mr. Preston about the nature of the townhome use, did that occasion further review regarding the sketch plan?
Yes.
And can you describe what happened there?
At that time, it was determined that there were two principal uses on the property. We reviewed it against the zoning ordinance, and 131802 came into play because there were now two uses on the property as opposed to the previous multifamily single use.
And 1318.02, and it's reproduced in City Exhibit 7, right? But the crux of this here is lot area or yard required. The lot area and yards required for any new building or use shall not include any part of a lot that is required by any other building or use to comply with the requirements of this ordinance. That's what it says, correct?
Correct.
Now, the three townhomes that we've gone over before, each of those is a separate building, right?
Yes.
So we have proposed three buildings on the property, right? Three new buildings.
Yes.
They are new buildings, correct?
Yes.
And the use is a townhome, a different use than a two-family detached dwelling.
Yes.
And there's reference to lot area in 1318.02. If we can go back to the definitional section in the zoning ordinance, and this is 1302.01 subsection A5. Let me know when you're there.
130201. I'm there.
A5, what does that say?
The word lot includes the word parcel, tract, or plot.
And then 1302.69. There's a definition of lot there, correct?
Correct.
It reads, a parcel of land fronting on a street used or designed to be used by one use or structure or by a related group of uses or structures, and the accessory uses or structures customarily incident thereto, including such open spaces as are arranged or designed and required in connection with such structure or group of structures. That's what it says, correct?
Correct.
And lot area means, that's in subsection A, the total horizontal area within the lot lines of a lot, correct?
Correct.
We've gone over before that lot, the word lot includes the word tract, right?
Correct.
So going forward in City Exhibit 7, the April 21st, 2025 letter. Past the reproduction of 1318.02. It reads, townhouses in the RT district require a minimum tract size of 9,000 square feet, regardless of the number of townhouses proposed. Is that correct?
Correct.
And you find that in, as cited, 1306.01A4, correct?
Correct.
And that's the dimensional table in the zoning ordinance for residential uses, right?
Yes.
Now it says, as you know, there is an existing two-family detached dwelling on the property. Under ZO section 1306.01A4, a two-family detached dwelling in the RT district requires a minimum tract size of 6,000 square feet. That's what it says, correct?
Correct.
This section 1302.01A5 of the zoning ordinance provides that the term lot, in quotes, includes the term tract, in quotes. And that's correct too, right?
Correct.
We just went over those provisions of the zoning ordinance.
Yes.
And your conclusion here is because the proposed development concerns a single lot, the lot area and tract size of the subject property are the same.
Correct.
You still agree with that?
Yes.
So it goes on to say, and I think this is just a typo on the lot size, right? It says the lot area of the subject property is 13,409 square feet. It might actually be, at least on their sketch plan, 13,408 square feet. But 6,000 of those square feet are unavailable pursuant to zoning ordinance 1318.02, correct?
Correct.
To satisfy the 9,000 square foot minimum tract size for the proposed townhouses, right?
Correct.
Because the townhouses, regardless of how many, require a minimum tract size of 9,000 square feet, right?
Correct.
And the two-family detached dwelling requires 6,000 square feet.
Correct.
I think when you add them up, you get 15,000 square feet, right?
Correct.
So if you have a property, one lot, one tract with townhomes and a two-family detached dwelling, you need at least 15,000 square feet, right?
Correct.
And they don't have that.
Correct.
If you go on to say excluding those 6,000 square feet, and that refers to the lot area required for the two-family detached dwelling, correct?
Correct.
There are only 7,409 square feet, and I guess it might also be 7,408 square feet, available to satisfy the minimum tract size for the proposed townhouses, which is insufficient under section 1306.01A4 of the zoning ordinance. That's what it says, correct?
Correct.
And you still agree with that?
I do.
Now, Mr. Taylor, Mr. Preston has asked you some questions about like if we've ever interpreted 1318.02 like this before. You recall those questions?
Yes.
Okay. And have we?
Yes.
No. Before
Oh.
Mr. Preston's victory on his interpretation on the townhome issues.
The prior to that, these were looked as multifamily.
And if you had a multifamily use designation imposed on a lot, even if you had multiple uses on the lot, would 1318.02 ever come into play?
No.
Because you have one designation, one use designation for the lot, right?
Correct.
So if we apply the multifamily designation to a lot, you never apply 1318.02. If you only apply a multifamily dwelling designation to a lot, do you ever apply 1318.02?
Not for the overall tract size. No.
Right. Well, if there's only a multifamily dwelling use on a lot, does 1318.02 ever come into play?
No.
You don't have different buildings, you don't have different uses, so that section doesn't come into play, correct?
Correct.
So under the city's historical and incorrect interpretation, did 1318.02 ever come into play?
No.
Right. So since Mr. Preston's victory on the interpretation, has the city implied 1318.02 in a manner consistent with the way you've done in your April 21st, 2025 letter?
Yes.
And if we look at City Exhibit 9, this is an
Mr. Deschler,
Oh, yes.
can I just ask you one
Yeah.
question about your question, just because I want to be clear? You asked him, 1318.02 doesn't come into play when you've said there's a multifamily dwelling because you don't have multiple buildings or you don't have multiple uses. I don't think that's correct.
sorry. I guess in my mind, I'm thinking about one building.
Okay.
The building would be.
Right, because aren't we talking about an instance where they took multiple buildings but called it a single use
Yeah. Well, I guess it would be a single use. We just have different
buildings?
different
Just wanna
buildings.
make sure.
Assuming they were all multifamily buildings.
You understand what I'm asking, Jim?
That if there's one consistent use, you don't need to,
Right, so I
Right
think
back
in the
to
past, the
1318.
question was, they took an instance where there was more than one building, called it a multifamily dwelling, so that made it one use, so you didn't apply 1318.02, but it didn't change the fact that it could have been contained in multiple buildings.
Correct.
Okay,
but it's 1318.02 wouldn't apply.
wouldn't apply because it was the use issue, right?
Yes, which is what's
Okay.
referenced in that.
In that stat, I just want to make sure, because Because I don't think the building is determinative.
And I agree with that.
Okay,
I think that's correct.
Well, yeah, I think certainly for the track size, because it doesn't appear dependent upon the number of, Building.
Right,
right, okay.
yeah, because when you said buildings, that was incorrect. I think you meant that, I think you were asking, because it's only a single use now, the multifamily dwelling, under that old interpretation. Okay, just want to make sure, because this is quite technical and quite convoluted. I don't want to miss something, but I think we'll all agree with what I'm saying. Okay. I threw you off your question. Sorry, but it was
No.
hanging in my head.
All right, so looking at City Exhibit 9, Mr. Taylor, this is a June 9th, 2025 email to someone named Michael Cox regarding 122 East Gap Street, correct?
Yes,
And obviously, if this is sent on June 6th, 2025 on D-Day, that's after your April 21st, 2025 email to Mr. Preston reflecting the city's interpretation on 1318.02, right?
yes,
So on City Exhibit 9, I think this is one of the properties you had mentioned during Mr. Preston's questions, right?
yes.
So if we look at the second page of City Exhibit 9, and just Mr. Taylor, what's the purpose of what we're looking at here? What is this?
That is a review of a zoning permit application, a plot plan, site plan that Mr. Cox had submitted for that property.
And the first comment on the second page of this exhibit, can you just read that for me?
The previously approved residential conversion is governed as a multifamily dwelling moving forward, zoning ordinance 1322.0304. Proposal is for a multifamily use, 2 separate buildings, and an additional single-family semi-detached dwelling, parentheses, twin. Zoning ordinance section 131802 limits the required lot area for each use to be separate and not overlapping. The proposed multifamily use requires 9,000 square feet of lot area, and the proposed single-family semi-detached dwelling requires 6,000 square feet of lot area. Parentheses, 15,000 square feet total required. Only 10,000 square feet of lot area is available.
So regarding this site plan, you applied the same interpretation regarding 1318.02 as you did in your April 21st, 2025 letter to Mr. Preston.
Yes,
And City Exhibit 10, is that simply the site plan referenced in City Exhibit 9?
it is.
And just where was the twin going to go?
The twin is on the site. On the site plan, the twin is on the left, the orangest block on the upper left-hand corner of the site, towards the upper left-hand corner, depending on how you're looking at it. I was holding it sideways.
Got it. And City Exhibit 11, this is a letter dated June 24th, 2025, authored by Craig D. Pfeiffer, Assistant Director of Planning and Zoning. And do you know Mr. Pfeiffer?
I do.
Is that the job title he currently has?
Yes.
It's dated June 24th, 2025 to Joseph Renko at Black Forest Engineering concerning a property at 1224 Eden Avenue, a sketch plan review. Is that what it is?
Correct.
And Mr. Taylor, if you can let me just say, on the first page of City Exhibit 11, there's a reference to zoning relief. You see
Yes.
that?
Yes.
What does that say?
It says zoning relief, the applicant shall submit an appeal application for the following. A dimensional variance to reduce the minimum tract size, 30,500 square feet required, 25,897 square feet existing. See also zoning comments 2 and 3. The dimensional variance to reduce the minimum side yard setback, 25 feet required, 10 feet proposed. C, a variance to exceed the maximum number of attached dwellings, 4 permitted, 6 proposed.
What was the proposal for this development? What was the nature of the uses?
The nature of the uses were that it was an existing single-family dwelling, and they were proposing to put 6 townhouses in the rear.
Was it an existing single-family detached dwelling?
Yes,
And they were proposing 6 townhouses to be built.
yes,
And there's reference to zoning comments 2 and 3 on City Exhibit 11. We go to page 4 of the exhibit. So zoning comment number 2, what does that say?
Zoning comment number 2, zoning ordinance section 131802 limits the lot area in yards required for any new building or use shall not include any part of a lot that is required by any other building or use to comply with the requirements of this ordinance. The zoning table shall be revised to indicate that the minimum lot size is 18,500 square feet, 6,500 square feet for the existing single-family detached dwelling, and 12,000 square feet for the proposed second use, single-family attached dwellings.
So again, we had on this property 2 different types of residential uses.
Yes,
And did you apply section 1318.02 to this review at the Eden Avenue property in the same manner that you applied it in your April 21st, 2025 letter to Mr. Preston regarding 312 Hanover?
yes,
And City Exhibit 12, is that just the site plan for 1224 Eden Avenue?
I'm not seeing it.
Way in here. It should be the last page, I
Oh,
think.
okay.
That's
Oh,
way, yeah. There it is.
yes,
And on that site plan, the existing single-family detached dwelling, the standalone residence, the standalone dwelling, is that at the bottom of the page?
yes,
And we have the 6 townhomes towards the middle of the page.
yes.
And Mr. Taylor, just briefly going back to City Exhibit 8, which is the May 21st, 2025 zoning application that we're here on this evening. This includes your April 21st, 2025 determination. But the narrative on the back, the last page of that exhibit, the narrative is dated March 21st, 2025 from Mr. Preston. And it reads, the applicant believes that relief should be granted because the city zoning officer has applied ZO section 1318.02, the applicant's site plan in a selective manner, which seems tailored to a desired result rather than applying said section logically and consistently. That's what it says, correct?
Correct.
Mr. Taylor, did you apply section 1318.02 in a selective manner?
No,
Did you apply it did you tailor your interpretation to reach a desired result?
no,
Did you apply it logically?
Yes,
In terms of applying it consistently, what was it possible to apply it in the way you have here prior to Mr. Preston's successful interpretation?
no,
And Mr. Taylor, have you ever been, was there any pressure brought to bear on you, whether from city officials or residents, to author the interpretation that's reflected in the April 21st, 2025 letter to Mr. Preston?
no,
You stand by that letter today?
yes,
I would move my exhibits 1 through 12.
You have any objection, Mr. Preston?
No objection.
They're admitted.
I have no further questions.
Do you have any redirect, Mr. Preston, before the
I
board asks
do.
questions? Okay,
I do.
we'll give you a minute.
Yep.
That's okay.
So, Mr. Taylor, the April 21st letter addressed to me over your signature is where you first announced to the applicant that section 1318.02 would effectively require them to add the minimum track sizes for any of the proposed uses. Is that correct?
that is correct.
Now, there were several examples you gave. I see 122 East Gep Street, which is included in City Exhibit 9. You testified about that, and you said you made the same interpretation there. Is that correct?
I applied the same section, yes.
Yes, and that was about 2 months after you sent the letter to me with that initial determination. Isn't that correct?
Yes, correct.
I'm trying to find the other example that you gave.
Exhibit 11, I think.
Nah, I'm not. Let me look here.
Yeah, it's the letter dated June 24, 2025 to Joseph Renko, Exhibit 11.
You're right. So that letter, June 24th. Again, that was about 2 months after the letter that you first sent to me.
Approximately, yes.
Yeah. Are you aware of any instances prior to the letter that you sent to me where the city had announced the interpretation that you're announcing since you sent me that letter?
Prior to the letter I sent you,
Yeah.
that was the first time I applied that section.
Right. So that was, it wasn't, but not prior to the letter that you sent to me. Is that correct?
I had not had an occasion to review any plans prior to that. I would have approved that section too.
Yeah, I'm not asking you why you did it. There may be very good reasons why you didn't do it, but other than the April letter that you sent to me, there were no instances prior to that where you engaged in this type of interpretation.
Correct.
That's what I thought. Okay. Now, okay, I have nothing further from Mr. Taylor.
Questions from the board for Mr. Taylor?
We have no opportunity to ask questions after we hear. Can we ask questions?
I think we'll have more opportunity.
I have a couple questions. Just as this has been a lot of information, so I want to clarify a couple things here. So, just like in absolute layman's terms, when you're looking at 131802 and you say lot area, you in your interpretation is including track size in that.
Correct.
Because I'm looking at this and I have two columns, one for track size, one for lot area. So we are to consider both of those as 1308.
Are you looking at lot area or lot area per dwelling?
I'm looking at minimum lot requirements, and I have track size and lot area per dwelling unit. So those are both included in 1308 or 1318.02.
13, I read 131802 as being applicable to the dimensional requirements in 1306.
In totality, both sides of that column, meaning track size and lot area per dwelling.
I just,
Well, all I'm going to say, I think there was a question that we confirmed. Your letter was taking the word lot area from 131802 and using the track size to deny Mr. Preston, correct? We all agree it's the track size.
That's an issue.
Right.
Yeah,
that
that's
issue.
right.
right, because the reference to lot area in 1306 is lot area per dwelling unit. There's no category.
I'm going to
for-
object. I would prefer
yeah,
that
no,
the
no.
board
I
solicitor
don't think you need
advise
to
the
say that.
board.
All I'm saying is, to clarify, we all agreed, and Mr. Taylor testified, track size is what he denied him on.
Yeah.
Okay.
Agreed.
perfect. Yeah.
I would just ask that the board solicitor advise the board.
Okay. So that's all we're considering, because there's I think where some of my confusion is the gentleman was saying that we're adding these numbers together. But we're not really adding, we're just adding the two track size numbers together, correct?
Correct.
So you're looking at the 9,000 and you're looking at the 6,000.
Yeah.
Correct.
It got confusing because at one point it sounded as if Mr. Preston was saying 9,000 plus 6,000 plus numbers under the lot area per dwelling unit column. We all agree that is not what is at issue here.
Okay.
It is track size of 9,000 and 6,000 so that everybody is clear.
Perfect.
Good question, because I do think it was still confusing if you, certainly for members of the board,
Sure.
who didn't study this for an hour before they came, like I did, so I could understand these two gentlemen.
Yeah, it's
We
just,
are challenging the track size. That's correct.
Track size.
But I'm not conceding that the lot area is not relevant. It's going to become very relevant soon.
Oh, no. But what I'm
Okay.
saying, the letter pertains to
Yes.
the denial. The three of us agree with the
Yep.
zoning officer's statement. The reason I said you are deficient, Mr. Preston,
Yes.
is 9,000 plus 6,000 equals 15,000.
Got it.
And you've got 13,408,
Agreed.
right?
Yes.
You can make other arguments then, and Mr. Deschler will have a chance to respond to that. But for now, let's stop at where we are.
that is the interpretation. We're looking
Right
at
now.
track size, those numbers, that's it
Mr. Preston may argue that somehow other things are relevant. We haven't gotten there.
at some point. Yes. Okay. All right. I think that clears it up. Thank you.
Yeah, good question. Anybody else? Yeah, but it's got to be questions about the interpretation, nothing else.
All right. Members of the audience, any questions for Mr. Taylor in regards to the interpretation only?
Okay.
And were you sworn in? I'm not sure when you guys came in. Okay.
And I'll say this for the benefit of anyone who's going to speak. Please don't think we are being rude if we say to you, that's not relevant because it doesn't go to the interpretation. Because we got to try to keep this confined to what the issue is. That's why I'm trying to be pretty strict at explaining to everybody what we're here on.
And these are
Yeah.
questions only.
Yeah, and questions based on the testimony Mr. Taylor gave.
There's a chance for comment later.
Understood.
Okay.
This is to a question that Mr.
Sir, can you
I'm-
give me your name, please?
Yes, Michael Pipestone. And do you need my address?
I need the spelling of your last name
Yes, last name is Pipestone, Pipestone.
and your address.
1130 West Market Street. Thank you. This is regarding a comment that Mr. Preston had asked about regarding the age of the original home that exists on the plot in question, and a suggestion that perhaps whether or not the rules would apply because it was built before the code was instituted. Can you clarify for me, Mr. Taylor, if your reading of 1306.01 in the building code has any comment on temporality of these rules, that they should apply only after a certain time?
Just to clarify, the zoning ordinance, you said building code. So.
Yes, zoning ordinance
Zoning ordinance.
1306.01, excuse me.
The current zoning ordinance would still apply to any existing property in the city.
Thank you. No further questions.
Oh, you're good. Thank you. All right. Anybody else?
Okay.
All right.
Next witness, Mr. Preston. I assume no one has.
Is that it?
I think so.
Just prepare to wait
Last
for a while.
chance. Any comments?
Okay.
No,
Let me say this. I think the two of you exhausted the
Are
questions.
we
we've been
doing
asking
comments
about
too?
this.
Because there's some people over here that said comments.
Oh, comments.
No, this is questions still.
Questions.
Just questions.
Yes. Yeah, because Mr. Preston has at least, how many, more than one or just one? Has another witness.
Wagner, are you ready? Sir. Okay. I'd like to call Dwayne Wagner as my next witness. Mr. Wagner, would you please identify yourself for the record?
Dwayne Wagner,
And what do you do for a living?
real estate development.
Okay. Give us a little bit about your background.
Background is all aspects of real estate development, from contract negotiation, construction, land development approvals, zoning relief, construction, operation, property management, all those sorts of things.
You've been doing this for a while.
Yes, over 30 years.
Okay. And you've testified as an expert in that area, the area you just described,
Yes,
in front of a zoning hearing before?
yes,
Okay. And you have some information with regard to the matter that's before the board this evening?
yes.
I would like to ask that Mr. Wagner be allowed to testify, give his opinion as to those matters.
Well, what's he being offered as an expert in?
Real estate development and zoning approvals.
I feel, I don't know that there's been a base established expertise, and even if there is, I don't see how that expertise would be relevant to reading the words on a page and deciding what the meaning is.
Can I respond?
Yeah.
Yeah, okay. Well, there's more to,
It'll give me time to think.
one person can read the words on a page and think they mean one thing. Somebody else can read them and think they mean something else. I think that's what's happened over history is the city has historically read it one way, but as of April 21st, 2025, decided to read it another way. And we can prove that that has switched. And that's what Mr. Delacour can do. We have,
Mr. Wagner.
I'm sorry, Mr. Wagner can do. We have properties, development approvals that all follow the same methodology that we believe that ordinance calls for, and it's not the methodology that Mr. Taylor has called for. So I think that information is relevant. And I think it's persuasive with respect to our argument.
If there are facts to be introduced from this witness, all well and good.
Yeah.
What I'm saying is, I don't think you kind of buttress the credibility by calling him an expert.
Okay. Yeah. So I think this is what we're going to do. I think we understand Mr. Wagner's background, but I do believe that's actually fact testimony.
Sure.
If he's going to point to projects, but the board can certainly take into account that we're not bringing in a sixth grader to try to interpret these things more. We have an experienced developer. I don't think it's expert testimony. I think it's fact-based testimony. Do we all agree? He can present facts as to prior projects and things of that sort.
Absolutely. And that's why I don't call Mr. Taylor as an expert, Mr. Preston didn't either, because I think,
Right.
I don't think you need to in
Okay.
this situation. Yeah.
Then the board understand. We're going to let him testify. You understand what he's doing, but it's going to be facts.
It's going to be facts.
Yeah, that's
Okay.
fine. Fair enough.
Just the facts.
I'm not ready now.
Just the fact, Mr.
Okay.
Wagner.
So, so you were engaged to do a little bit of research with respect to this application, is that correct?
Yes,
And In particular, you were asked to look at whether or not the city applies section 1318 the way that it's been described here this evening by Mr. Taylor. Is that correct?
Yes.
And what is your understanding of the way that Mr. Taylor applies the ordinance?
I believe it's applied on a cumulative basis by Mr. Taylor, meaning each use is looked at for lot area, and each use, each minimum lot area tract size that's required is added to the one before it to get to a total number, and that has to be equal to or less than the overall tract area.
Okay, and do you have a different view of how historically the city has applied 1318?
Yes.
And what is that?
It appears I have 3 factual examples only for developments that were approved, and the use areas on the lot areas for the uses add up to more than the physical lot area on 3 of the examples. And on one of the examples, the cumulative tract area would exceed the actual tract area. So it conflicts with the way
Well, let's do this. Let's break it down a little bit. So the examples that you have, these projects that are approved, were they approved prior to April 21st, 2025?
Yes.
Okay. And this is the exhibit that you've prepared?
Yes.
You mind if I hand that up? I'll keep one of those.
Oh,
Okay.
what are we up to, Jim? Let's see. Not many. I think it's
It's
A2.
A3.
I think it's actually A3, right?
Dwayne, I want to go through this. Let's take our time. Don't be in a rush. This information is important.
Mhm.
So I see this exhibit, which we're going to mark as A3. You prepared this exhibit.
I did.
Now, and where did you get the information that you put into this exhibit?
Off the City of Bethlehem website.
Okay. Now I see globally, it looks like there's 3 blocks. That is, there's 3 blocks separated by these 2 bold lines. Is that correct?
Yes.
And if I understand this correctly, each of those blocks pertains to a different property. Is that right?
That's correct.
The first block pertains to 218 to 226 West Union Boulevard. Is that correct?
Yes.
And there are 2 columns side by side that deal with that exact property.
Correct.
If I go to the second block, I'm looking at 1323 to 1339 East 4th Street with 2 columns dealing exclusively with that property. Is that correct?
Yes.
The third column is 2558 Linden Street, 2 columns side by side for the same property that talk about certain specifications for that property.
Correct.
Is that correct? Okay, now let's roll back to the first column. So the first column, which is 218 to 226 West Union Boulevard. I see the first column is called cumulative tract lot requirements. Second column is non-cumulative tract lot requirements. What do you mean in the first instance by cumulative tract lot requirements?
That would be adding the tract size, adding the tract size for each use. So for example, this is in the CL district. So the minimum tract size for the residential use is 9,000 square feet.
Is that what, that's the, what, 1, 2, 3, 4, that's the 4th line down.
Fourth line down. Yeah,
Go
the
ahead,
property, the date it was approved zoning district, the minimum tract size is 9,000 feet. And the minimum tract size for other uses is 2,000 feet. This property has a multifamily use on it of 39 units plus 1,600 square feet of retail use. So if you take the 9,000 plus the 2,000, that would be an 11,000 square foot minimum tract size, and the lot area, the tract area, is 38,997. So that would be adding those cumulatively It would be 11,000 feet, which is less than the total tract area.
So in the first column, I see that there's this particular lot was developed with a residential use
Yes,
and some other use
and a retail use.
and a retail use.
Yes.
The minimum lot tract size for the residential use from the table here that we're talking about, Article 1306, is 9,000 square feet.
Correct.
And the minimum lot or tract size for the retail use, according to table 1306, is 2,000 square feet.
Yeah, it classifies as other uses.
Okay, so if I add those together the way that Mr. Taylor said, then this lot is able to be developed with either of those uses or both of those uses.
Correct.
Now, the chart, as one of the zoning hearing board members aptly pointed out, has two columns side by side. In 1306, Article 1306, in the RT section, the first column, that is the first column with mandatory calculations in it, is labeled tract size. Is that right?
Yes.
The one immediately next to it is lot area. Is that right?
Yes.
That's the only one that has the words lot area in it. Is that correct?
Yes.
Now, the 131802, which is purportedly the genesis for this discussion, begins by saying that the lot area and yards required. You see that?
Yes.
That specifically mentions lot area. Am I correct?
Yep.
And that's for any new building or use, correct?
Yes.
So, as you've stated in the first column, this particular property is eligible for both a combination of a residential and the retail use because it has more than 11,000 square feet, which is the total of the 9 and the 2, right?
That's correct.
And this has a lot area of 38,997. Is that correct?
Yes.
Now, there's another calculation that the ordinance requires with respect to lot area, isn't that right?
Yes.
And what is that calculation?
It's the density calculation or the use calculation for the intended use on the site.
Okay, and that's expressed as minimum lot area. Again, I want to focus on that term. Minimum lot area per dwelling unit. Is that correct?
Yes.
And in this instance, what is the minimum lot area per dwelling unit?
In the CO district, it's 1,200 square feet. However, in this case, a zoning variance was granted and it brought it down to around 1,000. The variance was granted for 1,017, but I think it ended up being around 1,000.
So under the plan approvals for this, there was a required minimum lot area of 1,017 square feet per dwelling unit. Is that correct?
Correct.
So the multifamily units, there were 39 total.
39 approved units.
Okay, so what is that? What am I looking at? What's the
So
38,997?
the 38,997 is the total that's on, if you look at the next page, they're using roughly 1,000 square feet. It's in the red box in the lower left corner. Minimum lot area per dwelling unit per the ordinance, it's 1,200 square feet. Per the plan, it's 1,000 square feet, and that references note 2, which was granted, it was granted zoning relief for that. So 39 units consumes the entire tract area of 38,997 square feet if you assume just slightly less than 1,000 square feet per unit.
So if I go back to my chart at 1306 and I go to the column that's actually called lot area,
Mhm.
and I run the calculations as you have done, I find in this particular example that the number of units, residential units on the lot consume the entire square footage of the lot based on the required calculation of lot area per dwelling unit.
That's
Is that
correct.
correct?
That's
That
correct.
would leave no lot area left over for tract size. Is that right?
That's correct.
Now, tract area remaining after the multifamily use lot area requirement, you have a 0 there. Is
Correct.
that what we just talked about?
It is. That's the area above the 38,000, the two cells above 38,997, which is the tract lot area, subtracting out the 38,997 that was consumed by the residential units, gets a net lot area left of 0.
Lot area, and then the retail use was added on to that.
Then there's a retail use of 1,600 square feet, and that's referenced on page 2, The second red box shows 4 spaces times 1,600 square feet of retail. So the retail use has 1,600 square feet in addition to the 38,997, which would result in a deficiency of 1,600 square feet if everything was cumulative.
If you added in the track size and deducted it,
Right. If
Ahead
all,
of
if all
time.
uses were subtracted from that single lot value.
okay, you would end up with a net deficit in square feet.
Correct.
This plan is not, this plan is not consistent with the zoning ordinance then.
Correct. Under a cumulative review, it would not be.
Under the scheme that's been proposed by Mr. Taylor, this particular plan is not lawful.
I believe that's correct.
Let's take a look at the next column, which says non-cumulative tract lot requirements. Now, when you say non-cumulative, I believe this is consistent with our theory of the case that says you don't keep adding up the tract size. Is that right?
Correct.
So let's take a look at what happens there. Same thing, same plan, same date, same district. Again, the first set of information is sort of redundant. The 9,000 still applies. The 2,000 still applies. Lot area, here we have the same calculations. We run down to the multifamily units times lot area. Again, we end up at the same place, 38,997 square feet. That's consumed by the
That-
apartment units.
Correct. That use of the apartment units consumes the available land or the lot area. So the use of apartments requires 38,997 square feet of lot area. That is equal to the lot area. So that would, in a non-cumulative basis, that would pass the test. Is it equal to or less than the lot area, the square footage that's required for that use?
Okay, so if that lot area, if I look at 13 and 18.02, we've been told that this can only be read one way. If I look at that, and it says the lot area and yards required for any new building or use shall not include any part of a lot that is required by any other building or use. So if all of that acreage, which is the total acreage, is required for the lot area per dwelling unit, how much area is left over for tracks and,
For the,
well, I'm
re-
sorry,
for the retail,
for the retail use?
there wouldn't, according to the way that's written, there wouldn't be any lot area left. But based on using them on a non-cumulative basis, where you look at each use independently, you have 38,997 square feet of lot area. Your residential multifamily use requires 38,997 square feet of lot area. That passes. Then you have a retail use of 1,600 square feet, which is less than 38,997 square feet. So both of those uses would be applicable, and they were approved as uses. And I believe that's based on the other components of the zoning ordinance and saldo relative to parking requirements, setbacks, and other things like that.
Okay, so under Mr. Taylor's interpretation, if we keep chopping these things off or double counting them, this plan for 218 to 226 West Union Boulevard, under that theory, would violate the zoning ordinance.
Correct.
However, if you follow the reasoning or the rationale that we're proposing, it would not.
Correct.
And it appears that the city, because they approved the plan after review and so forth, that it's more likely than not that they didn't adopt Mr. Taylor's reasoning. Is that correct?
That's correct.
Let's take a look at the next column, which is 1323 to 1339 East 4th Street. Let's do the same exercise. Let's start with the left column. I see the date December 14th, 2023. What does that tell me?
And that's the date the plan was approved.
Okay. And again, here we are in a CL zone.
Correct. CL district.
Go ahead. I see 9,000 and 2,000. What's the significance?
It's the same 9,000 and 2,000 as the prior example. 9,000 minimum tract area, tract size for residential use,
Mhm.
2,000 square feet required for any other use.
Okay, so if we add those up, we get 11,
Correct.
and the area itself of the lot is 40,555. Is that correct?
That's correct.
So those two would be able to,
They would be able to coexist.
they would
Yes.
be able to coexist, but they can't consume lot area that's required for any other new building or use. Is that right?
Correct.
So Let's run down through the list here. I see minimum lot area per multifamily unit is 1,200, right?
Correct.
Then what happens? What's the next number?
The
Tell
next number is 587.75. That also was, that property also received the variance for the lot area required per dwelling unit. So it was reduced from 1,200 square feet to 587.75 square feet.
Okay.
The next number is 69 units.
Mhm.
So if you multiply 69 units times 587.75 square feet, that equals 40,555.
Mhm.
So if you take the total tract area of 40,555, subtract off the area required for the multifamily use, which is 69 units times 587.75 square feet, that equals 40,555, netting a zero square footage left on the tract after that use is
Mhm.
accounted for.
Mhm.
The next number is 4,000. This property also had a mixed use on it, and there was 4,000 square feet of retail space provided. So if you have zero tract area left because the multifamily consumed it, and you're also putting 4,000 square feet of retail on the site, you now have a deficit of 4,000 square feet of tract area if things are counted for cumulatively.
Okay, and then right next door, the next column for the same property, 1323 to 1339, we now have the non-cumulative tract lot requirements. This is where we're saying that you don't double count the tract area.
Correct.
Go
So in this case, the minimum tract size for residential use is 9,000 square feet. That is less than the tract size of 40,555. That passes. The minimum tract size for other uses, again, is 2,000 square feet. That's less than the 40,555, so that also passes. Same math follows suit coming down. The minimum square footage is 1,200 square feet per unit. However, the variance granted to 587.75 reduces that. So your total area dedicated on the tract to multifamily is 40,555 square feet, which is the product of 69 units times 587.75 square feet. So that passes on a non-cumulative basis. There's 40,555 of residential use on a 40,555 lot. The next test would be on the retail side. There's 4,000 feet of retail being proposed or approved on a lot that's 40,555. So that leaves an excess of 36,555 square feet. So on a non-cumulative basis, that the numbers all pass.
So with respect to 1323 to 1339 East 4th Street, if we adopt the cumulative tract lot requirements, as Mr. Taylor has suggested, that plan violates the ordinance.
Correct.
If we don't adopt that and we go with the methodology that we believe actually applies, that plan does comply with the ordinance.
Correct.
Let's take a look at the third column. And I just want to point out, you have some other pages back here. We'll get to that in a second. Let's look at the third column, which is 2958 Linden Street. And let's do it, same exercise again. Let's start with cumulative tract lot requirements. This is the column that talks about an analysis in accord with what Mr. Taylor's proposing.
Correct. So on a cumulative basis, this property was approved in August of 2021. This, unlike the prior two, is in the CS district that has different minimum lot tract size requirements. Under the residential use, it requires a minimum of 2,000 square feet per unit. Under other uses, it's a 2-acre minimum. So this tract in total is 2.81 acres. So in order to put our use of 61 apartments, we would need to consume 21,610 square feet. That's 2,000 square feet times 61. So that utilizes the entire tract area to get to the tract area is 2.81 acres. The residential use requires that much area, so it would pass.
Mhm.
However, when it's added and there's also a restaurant use on the site,
Mhm.
it's a freestanding 2,400 square foot building, that would require 2 acres. So on a cumulative basis, this plan would have required 4.81 acres
Mhm.
of lot area or tract size
Mhm.
to be compliant. So if we that's on the compliance side for the tract size.
Mhm.
So if we follow down below, the tract area is 21,610 square feet. That's 2.81 acres. I have a minimum area required of 2,000 square feet per unit. We actually provide 2,010, so we're at 61.2 units is what was approved. So we actually have 61 units because you round down. So the multifamily area on this property requires 21,610 square feet of area,
Mhm.
and the tract is 122,610 square feet, again, leaving us with 0 square footage available for the restaurant use. When the restaurant use is accounted for of 2,400 square feet, that leaves us 2,400 square feet short.
Okay, and that plan wouldn't comply.
That wouldn't comply, and that's similar to the others, but the notable difference is the tract area on the CS, because it's a CS district, would have had to be 4.81 acres, and it's only 2.81 acres, unlike the other two where it did make sense. It did
Mhm.
pass in the CL. So on a
But-
non-cumulative basis, we have the same situation here. So we have a 2.81 acre lot. The residential use requires 2.81 acres, so that passes. On a non-cumulative basis, the restaurant use or the other use requires 2 acres. The lot is 2.81 acres, so that also passes. So viewing it on a non-cumulative basis, the lot area and minimum tract size are compliant. The use per the multifamily equals the 122,610 square feet, which is equal to the tract size. So that's compliant on its own. And the 2,400 square feet for the residential or the restaurant use is also less than the tract area. So that complies. You actually have 120,000 feet left over after accounting for the restaurant other use.
Okay.
So
That scenario does comply with the zoning ordinance.
yes,
So in each of these 3 cases, if we apply Mr. Taylor's methodology, we end up with a plan that violates the zoning ordinance.
correct. The first two under the CL, it violates it under the what was approved, the approved uses on the tract size.
Right.
And under the CS district, it violates it in the minimum tract size as well as the total uses combined on the site.
And that's because you're making all these deductions that Mr.
Correct. And
Taylor is
cumulative.
requiring you to make
Correct.
as of April 21st.
Correct.
Let's just go through these pages because we haven't looked at them and I don't want to assume people know what they are.
Yeah.
The second page where it's the 226.
Yeah, 218 to 226
218,
West Union.
What
This-
are we looking at there?
This is a blow up of the next page, which shows the approved site plan. And it's just a blow up because it's a little tough to read the
Oh, I
overall
see.
site plan. So I
So
just
the
blew it
third
up.
sheet is the site plan.
The third sheet's site plan, the second sheet is the blow up of
And
the
in front of
zoning
the site
information.
plan, you put a blow up of the site data.
Correct,
Okay. And this is where you got a lot of this information from.
correct.
Very good. Zoning data, minimum tract area, minimum lot area per dwelling unit. Okay. I see minimum tract area per the ordinance. I see 9,000 square feet.
And they have 39,000 square
Yep.
feet.
I'm sorry, I didn't hear that.
And they have,
The minimum required is 9,000 square feet and the property has 39,000 square feet.
let's take a look at the next set here. Again, it's the same methodology.
Same methodology. This box notes that it's a CL district. It's a mixed-use development with 69 apartments and 4,000 square feet of commercial space. That's the intended use.
Mm-hmm.
So again, 2 uses identified there.
I see here, let me back up a second. If we go back, this is the second page.
Mhm.
And the box that you have circled here, there is both a retail and a residential component. Is that correct?
Correct.
The minimum tract size for the residential component is what? Here's-
9,000 square feet.
It's 9,000
Sorry,
square.
Mr. Wagner, you're trailing off a little bit. Could you
Oh,
just raise your
that-
volume, please?
Is that better? Sorry.
Yep.
9,000 square feet.
The minimum track size for the commercial component, I have the chart here if you need it.
Was 2,000 square feet.
So that was that minimum track size, is that right?
Correct.
And it's our belief that you just need to meet the greater of the track sizes for either use.
Correct.
Okay. They were saying that you have to add those, so you would need a minimum track size of 11,000 in this case.
Correct.
Okay. I look at the site data here and I see minimum tract area. I only see a 9,000. Do you see that?
Yeah.
They don't appear to have added 2,000 to that, do they?
They don't, and they also don't call out the square footage that is related to the retail in the statement of intent. That's why I highlighted it. To the right of the box in the lower left is, it shows you 1,600 square feet of retail for the
So-
indoor. That's a
It
parking
wasn't hidden.
calculation.
No, okay.
No.
Let's keep going. 1, 2, 3. So here's 4. Let's go to the next one. This is the site data. This is for the East 4th Street property. Okay, and this had a commercial and a residential component. Is that well?
Correct.
And the residential component, the minimum tract area is how much?
9,000 square feet. That's just below, there's a red box on the right-hand side. Just below that has the lot and setback regulations for multifamily. First item is required 9,000 square feet of minimum lot area.
So that's all that's required
Yes,
according to this site data. You didn't produce this table, right?
No.
This is off the approved plan.
correct,
Sorry, I didn't hear that last question.
This is off the approved plan. Is that correct?
correct.
Now, the retail component, does that have a minimum?
It does. Just below that, you'll see a lot and setback regulation for commercial,
Mhm.
and that has the minimum lot area of 2,000 square feet.
Okay, let's keep going. And the final one, which is the Linden Street property. And again, we'll drop back into the site plan. Let's see here. 2 acres. I see the minimum lot area here is 2 acres. And where does that come from, if you know?
That comes from the zoning chart, the zoning ordinance under,
Yeah.
that's under C.
Keep this there all the way back.
CO. That's under 130601B2 CL commercial and sorry, my minimum lot sizes are here. Track size, let's see. CS, sorry. It's on page, it's 4. It's 1306.01B 4 is CS, CS Shopping Center District allowed uses. Minimum average of 2,000 square feet of lot area shall be required per dwelling unit. And then to the right of that is minimum lot area of 2 acres. That would be for any use other than multifamily, you need a 2-acre minimum lot size. If you're doing multifamily, then you need to provide 2,000 square feet of lot area per unit.
But that's not in this table. They just go with the minimum that's listed in that
Correct.
minimum tract area. They're not adding all these minimums up as Mr. Taylor is suggesting.
They're not cumulative.
No, they're not cumulative. And that's on those approved plans.
Correct. And the statement of intent here identifies its proposed 61 apartments and a restaurant.
I have nothing further for this witness.
All right. So, Mr. Taylor, looking at the first property that is in this table, 218.
We're on cross for Mr. Wagner.
Oh, sorry. Yes, Mr.
Yeah.
Wagner.
Oh, you said
Yes.
Mr. Taylor.
Yes.
He
sorry.
started.
Attorney Deschler, can you use your microphone?
I can.
Yeah.
Is it on?
Mr. Wagner, looking at the first property in the table, 218 to 226 West Union Boulevard. Just so I understand the analysis here, the minimum tract size for, I guess, let me back up. The residential use was a multifamily use, correct?
Yes.
All right. And then you had commercial use, right?
Yes.
So you have in here the minimum tract size for the multifamily dwelling use was 9,000 square feet. the minimum tract size for all other uses, including this commercial use, was 2,000 square feet, correct?
Yes,
Right, so you add them up, you get 11,000 square feet, right?
yes,
And the tract size of this property was 38,997 square feet, right?
yes.
So I'm struggling here. Under Mr. Taylor's interpretation, why would there not be sufficient tract size?
There's sufficient track size based on the requirement of 9,000 and 2,000. If you add those up, it's 11, as we just said, and the tract is 38,000. So there is sufficient.
So applying Mr. Taylor's interpretation, there's sufficient tract size.
Correct. But when you actually look at what was approved for land, the requirements of the lot area for what was approved, it exceeds the physical tract size. Because you have 39 apartments that consume the 38,997 square feet of the tract size, and there's another 1,600 feet of retail. So the lot area required under 131802 would account for the retail use as well as the residential use, and combine those and make those cumulative as the lot area, tract size area is cumulative. Just being consistent. That's what I was doing in that column. Just consistently keeping it a cumulative analysis.
All right, the minimum lot area per dwelling unit per the ordinance, as indicated on the plan, was 1,200 square feet, right?
Yes.
And I don't have, I mean, this was from a few years ago. I mean, that applies to the dwelling units,
Yeah.
not
That
to the commercial space.
correct.
You know what the commercial minimum lot area per, I guess it's not a dwelling unit, but minimum lot area per unit is?
It's not. I don't believe it's a per unit. I think you just have to have 2,000 square feet of minimum lot area in order to put other uses other than residential, because the residential refers back to the RT. Yeah. I don't believe there's a minimum for the retail use, other than it's classified as other under the CL. I have that. Yeah, minimum lot area under the CL is 2,000 square feet.
All right, well, okay, so under the ordinance, if there are 39, right, there are 39 multifamily dwelling units, correct?
Yes.
And if the lot area, or sorry, the minimum lot area per dwelling unit is 1,200 square feet, right? Yes?
Well, that's what's in the zoning ordinance. However, this property did receive a variance to reduce that minimum.
No, I get that, but
Yep.
Even if we just go with what the ordinance says,
Then the,
wait, 39 units times 1,200 square feet per unit gets you to 46,800 square feet. Right?
correct, that would be not, that would exceed that. You couldn't put 39 units on that property using 1,200 square feet. You would have to take the 38,997 of the tract size and divide it by 1,200.
But I'm just saying, just not even focusing, just sticking on this, even though I don't really see how this is relevant, but sticking on the lot area per dwelling unit part of this. Forget the commercial component. If we just looked at this as a multifamily dwelling building, there would not be sufficient minimum lot area per dwelling unit to pass muster under the zoning ordinance, right? You would need a variance,
Assuming a 1,200 square foot
right?
minimum per dwelling unit under the multifamily, and you have 39 units, you wouldn't have enough square footage on the tract size to get that number. Correct.
Without focusing on the commercial use, just focusing on.
I'm just answering your question.
Right.
Yep, 39 times 1,200 exceeds 38,997. So you would have You'd either have to get a variance or do less units.
Again, and that's just looking at this, that single use, correct?
I'm just trying to answer your question. Yep, just looking at the unit, one specific question. Yep.
Right. Well, that's my question now. Just looking at that one single multifamily use, there's not enough lot area to satisfy the minimum lot area per dwelling unit, right?
Based on 1,200 square feet per
Correct.
unit? Correct.
And I guess for 1323 to 1339 East Fourth Street, that's correct as well. If you have 69 multifamily dwelling units with a minimum lot size per dwelling units, as you have listed here, of 1,200 square feet, you would need, just for that type of residential use, 82,800 square feet, correct?
That's correct.
And this lot has, it's 40,555 square feet, correct?
Correct.
But also applying the, for the, so just, that was for the lot area per dwelling unit, looking at the tract size, I think you testified to this, applying Mr. Taylor's analysis of combining the 9,000 square feet plus for the residential use, plus the 2,000 square feet for the commercial use, you get 11,000 square feet, right?
Correct.
And there's sufficient tract size to accommodate those two uses, right?
Correct. And
Yes, yeah.
that's why I put the two columns there, because accounting for the use cumulatively, being in the 9,000 plus the 2,000 gets you 11. That is less than the tract area of 40,000 square feet. So then I treated the uses on the lot cumulatively as well.
But I guess, again, under Mr. Taylor's analysis for the issue of the tract size, these first two lots we've looked at are compliant, right? With the combined commercial and residential uses, there's sufficient tract size, right?
Correct. They're correct in the tract size, but when you look at 130802, and this is, you're going to look at the lot area and yards required for any new building or use shall not include any part of a lot that's required for any other use. That's where the plan, it seems inconsistent that the lot tract size is treated cumulatively, but the uses on the lot are not treated cumulatively.
Well, I'm trying, and this is what I'm trying to get at. I mean, Mr. Taylor's letter from April 21st, 2025, in the second paragraph from the bottom on the first page, it says townhouses in the RT district require a minimum tract size of 9,000 square feet, regardless of the number of townhouses proposed, right?
Correct.
So,
Yeah, I see that.
So I know I guess you disagree, but you understand that the city's interpretation here is we're adding up the uses to see if there's sufficient minimum tract size, not the units within each use, right?
Then, correct. So if we
Okay.
look at the third example, we looked at the first two. Do you want to continue to look at the third example?
Well, I just want to but the first two, again, Mr. Taylor's, under his interpretation, there's sufficient minimum tract size to accommodate the residential multifamily use and the commercial use, right?
If I look at it under the lens of it being cumulative, the way it's written in Mr. Taylor's letter, the uses meet the requirement, the minimum tract size for the uses combined meet the requirement, but the uses approved on the lot when combined exceed the size of the lot. So I'm agreeing with you that the 9 and the 2 appear to be compliant with the Mr. Taylor's letter, that you would add those two up and they're less than the total of the lot. So they would work. And if you carry that same logic, cumulative logic, through to what actually was built on the lot, they exceed the square footage of the tract. So while the uses of 11,000 square feet are less than the tract size of 39 or 40,000, the uses that were actually approved when looked at under the same lens of being cumulative exceed the square footage of the lot tract area.
But for the multifamily use at 218 to 226 West Union Boulevard, is that just, I don't know what the property looks like. Is that just a single apartment building?
Which one?
Yeah, I believe it's
It's
not built yet. It's approved. I believe it's one structure. I'm not sure if it's two structures. It looks like it's one footprint, but
But okay, so it's one structure.
with two uses, yeah.
All right, but that's the only building on the lot, right?
Yeah, well, I believe it is. It's not built. It's a vacant lot right at the bottom, right where Union Boulevard and 378 connect.
But it's okay.
It appears to be a single building with two principal uses, one being multifamily and one being retail.
And I mean, all right. So like we talked about before, if you just look at the residential component of that, there's not sufficient lot area per dwelling unit, which I guess is why they got the variance, knocking it down to 1,000 square feet per dwelling unit, which gets you at 39,000 square feet, right?
Yeah, it appears the residential use consumes the entire square footage of the tract. That single use does. When you take the per square foot requirement per unit.
Right, and that's how that was. Isn't that how that was analyzed though? If there's a variance granted to knock it down from 1,200 square feet to 1,000 square feet, and there are 39 units proposed, yeah, you're exhausting the units, but you have enough space to put those units in, right?
It depends on how it's designed, if you have enough parking or what other constraints are on the site. I would assume so. They received the land development approval that had to have looked at setbacks, yards, parking requirements, drive aisles, all that sort of thing. So that's the second part of it. Just because the math works, you still have to make accessibility, drive aisles, and compliance with everything else under the ordinance.
Okay. And just on the last one, the 2958 Linden Street project,
Mhm.
right? So, and I see from the pages in the back under zoning notes, minimum lot area 2 acres, proposed 2.81 acres, right?
Yeah, there's 2.81 acres on that lot.
Right. So there, so just, and I guess that the 2 acres applies to the other uses, right?
Right, it would apply, in this case, the restaurant use, but any other use, it just simply says 2 acres. And then the residential requires 2,000 square feet per unit.
And sorry, have all these projects received approval?
Yes.
Okay, and in each case, the approval are they all from 2023?
No, August of 21, December of 23, and July of 23.
Okay, so the Union Boulevard was 2021.
Union Boulevard was July of
Oh.
23. Yeah, you
Sorry,
got it.
They're all right here.
Yep,
Union Boulevard 2023, East 4th Street 2023, and the Linden Street project 2021, right?
correct.
All right, so all of those approvals were before Mr. Taylor issued his letter in March of 2025 correcting the city's prior interpretation regarding the multifamily use designation, right?
Is that this letter from April? From April 21st, I think, is that one?
Now, I'm actually focusing on the March 20th,
Okay,
2025.
that's why I
letter.
wanted to confirm. I don't.
That's City Exhibit C5. This is where Mr. Taylor revised the city's longstanding interpretation, right?
There you go. March 20th, 2025?
Yes. All of these three projects that you've gone over in Exhibit A3, they were all approved prior to Mr. Taylor's March 20th, 2025 letter, right?
Correct.
And in terms of what's proposed for the property at 312 Hanover Street, you agree with me that there are two principal uses proposed, right? I know one's an existing and there are three proposed townhomes, but there are two principal uses, right?
I believe principal uses, yeah.
If you know.
If you know?
I'm not sure if it would be classified as a principal use, but I understand there's an existing two unit dwelling, family, two dwelling unit, and they're proposing three. I don't know if it's classified as principal or not, so.
Okay, but there's a existing two-family detached dwelling, right?
Yep.
And they're proposing three townhomes, right?
Correct.
And you've testified you're very familiar with how zoning works and everything like that. Neither of those, the existing two-family detached dwelling or the three new townhomes, neither of those is a multifamily dwelling, right?
No, I think under the ordinance, the townhouses are, if it's a 3-unit building, that would be multifamily, but I think they exclude townhouses from that.
And
So because it's a townhouse, it's not a multifamily.
and as a representative of the property owner, you don't want a multifamily dwelling designation to apply to that lot, right?
I'm not,
That,
don't know that answer.
And just Mr. Wagner, regarding the Union Boulevard property,
Mhm.
When on the second page on the plan, when it lists minimum tract area, it says 9,000 square feet, right?
On the Union Boulevard property, yes.
And-
And that's also on the page 2 of the plan. Also references that as the tract area in the CL district.
And it focuses on the minimum tract area for a multifamily use, right?
Yes,
It doesn't address the commercial use, correct?
correct. The one, and that's the way the plan was done, but the one for the 1323 East 4th Street does provide both the multifamily and commercial breakdown, a little more comprehensive.
Mr. Wagner, regarding section 1318.02, I think you've referenced that there's a differing interpretation that you have. What is that interpretation?
My interpretation is that the lot areas have not been treated as a cumulative requirement, that they've been looked at individually. So in other words, if you take the 2958 Linden Street property, you need, in order to put 60, we have a 2.81 acre lot, divide that by 2,000 square feet, which is the required minimum per unit, then we could get 61 units there. So that would equal the minimum that's in the zoning ordinance, the 2,000 square feet. We want to put a restaurant use on, that says you need a minimum of 2 acres. The lot's 2.81 acres. We comply under both of those. And then the uses, what allows us to get the combined uses on that site of 61 units and the restaurant use is how the lot configuration is engineered to make sure it complies with all of the other aspects of the zoning ordinance. That's been my experience. They have not been viewed in a cumulative manner. They've been viewed that the area being used within the lots can't conflict with each other, and you have to provide enough of all the other things in the zoning ordinance. Like I said before, drive aisles, parking spaces, ADA ramps, garbage storage areas, that sort of thing, whatever is required, rear yard, front yard, side yard setbacks, which would be consistent with all three of these examples, because under the Union Boulevard property, the uses of the 38,997 square feet of residential with 1,600 feet of retail exceed the physical square footage of the lot. However, they're able to be configured where the development works. Same thing with the 4th Street property. They both got variances to reduce the square footage minimum of lot area for the apartments, but the use, when you add up the 40,555 being used for residential and the 4,000 square feet of the retail use, you're 4,000 square feet short of physical lot area to fit those uses on the lot. So I think that's where they defer back to, in my experience, has been, do they work and does the development comply with all the zoning ordinance and saldo requirements?
And the Union Boulevard property, right, that's going to be one building, right?
I believe so. That's what's on the plan. Yes.
Okay, and for the 4th Street property, is that also one building?
That's also one building, but both of them have, again, as we talked about principal uses, there's 2 principal uses within the building. The retail use, which has a completely different requirement for the commercial use that's there, for access, egress, square footage requirements, restrooms, parking is also different for the retail use.
And the Linden Street one, does that development just include one building?
No, if you look at up towards Linden Street, there's a restaurant pad
Okay.
up on the upper left corner, and then the long building is the apartments. But they're located on the same lot.
So regarding 1318.02, you're taking a historical perspective on how, I guess you're saying that section has not been applied, right?
Correct.
Can you give me an example of a situation where 1318.02 would apply? How it would apply?
Well, it would, if I read it, it would say that it would be separate, the lot area. And again, is that the lot area is the question the gentleman on the board asked was, I don't know where the tract size comes in with lot area, because it's being specific to the lot area. When I go to that part of the zoning ordinance, I look at the minimum lot area per that use and then the yards that are required. And I view the lot area and yard requirements as different from the tract size. Again, it's putting, is the lot able to accommodate the use because it meets the requirement? And then how is that use imparted onto the lot? And that's how I read 1318.02. It's really the functional development of the lot after you've crossed the threshold that use is permitted on that lot.
Just take I omit like the historical baggage.
No, that's how I read it. I'm looking at a lot.
But can you give me an example? I mean, you're just kind of saying words. I mean, not in the abstract, but like, give me
That's what people do. They say
no,
words.
he's presented supposedly concrete examples of I don't know what. But can you give me at least a hypothetical? An example
I can do that. You want me to do that?
Of what situation with 1318? Well, he's the witness. In what situation would 1318.02 actually apply?
I think 1318.02 would apply in any situation where development plan is submitted to the city. That was your question. What situation would it apply? It would apply to every situation.
You're saying that a provision of the zoning ordinance applies to zoning matters. I get it. Is there any situation that you can think of, any kind of scenario where you could see 1318.02 applying? In what way?
Yeah, I think it would apply if it applied.
Read all of it. Read the entire thing.
1318.02, lot area or yard required. The lot area and yards required
Can't sell it.
for any new building or use shall not include any part of a lot that is required by any other building or use to comply with the requirements of this ordinance. No required lot shall include any property, the ownership of which has been transferred subsequent to the effective date of this ordinance, if such property was part of the area required for compliance with the dimensional requirements applicable to the lot from which transfer was made. Exception, where a tract of ground in single ownership is split by a residential zone and a non-residential zone, the non-residential portion of the tract has been used to establish maximum allowable density on the residential portion of the tract. The non-residential portion of the tract may be conveyed to an adjoining non-residential property, and the remaining portion of the tract shall not be considered non-conforming in any way. any manner regardless of whether the density conveyed or portion has been used to establish residential
Fast.
density.
I'm sorry, Mr. Wagner, you're kind of talking too fast there at the end, so.
Okay, sorry about that.
Can
It was basically reading the section 131802. So
I don't know where you left off, but I'll figure it out for you.
Wait, can Mr. Preston cannot direct the witness?
Yeah.
what if you're saying where would you apply that to? I think you would. Why wouldn't it be applied to 218 West Broad, where this is saying that it shall not include any part of a lot that is required by any other building or use to comply. So if I use 38,997 square feet of the tract in order to get 39 apartments, that would be one use.
You said West Broad, you mean West Union?
West Union,
All right.
yeah, West Union, right? So I have 39 units. They require 38,997 square feet of area, right? So
So are you saying that if 131802 applied, well, so you're saying 1318.02 by its term should apply to West Union?
but you asked me if there's this, if I can provide an example where it should apply. That's an example where it should apply. It's a development in the city. And is it being, well, let me ask you, let me understand. Should I apply it consistently in a cumulative or non-cumulative way?
I'm asking in a situation with 1318.02 actually limit development because of the language in there about how lot area and yards required for any new building or use shall not include any part of a lot that is required by any other building or use. Mr. Preston, can you not whisper in his ear?
I'm deaf anyway. It doesn't matter.
Very
Okay.
depressing.
I got,
Oh, I was going to say, are we going to have to separate you two? Come on.
Where would that come in applied to limit development in the way that the term seems to suggest?
if I have to account under this, if I have to account, now I'm alone. What am I going to do? If I have to account for the use of the multifamily apartments, and let's use West Union Boulevard as an example. I have 39 apartments that were approved, and they require 1,000 square feet round numbers. That's 39,000 square feet. The lot is 39,000 square feet. If I've consumed all of the lot, can I put any other use on that lot?
If the track, I mean, there's 11,000 square feet of track size.
No, the tract is 39,000 square, physically
Well,
39,000
But the
square.
minimum track size is combined 9,000 plus 2,000 is 11,000 square feet, right?
No, that's this. So we're going cumulatively or non-cumulatively?
Cumulatively.
Okay, so we're going to look at the tract size cumulatively, and we're going to take each use and add them together, and that's 11,000 feet.
Right.
So the combined cumulative two uses are 11,000 square feet, which is less than the 39,000 square foot lot area.
Yes.
Now I'm going to apply the lot area and yard required for each use, independent of each use, right? Because that's what 131802 says to do, right?
Okay, go ahead.
Is that correct? I don't want to go down the wrong path.
How, in what situation you'd apply this?
Well, I'm getting there, but
I'm listening.
yeah. So I want to make sure we're on the same page. We know that the uses are compliant and meet the minimum tract size, 11 versus 39. So now 131802, the lot area and yards required for any new building or use shall not include any part of a lot that is required by any other building or use to comply. So I have two uses that added up to 9 and 2 for 11. So let's start with the multifamily, right? I need 9,000 minimum. I have 39, I'm fine. I have 39 units at 1,000 square feet each, round number, agreed?
Yes.
That's 39,000 square feet.
Per the variance, right?
Correct, based on the variant. Otherwise, it'd be 1,200. If we want it, we can use the 1,200, but it's not a real world example. So we have 1,000 square foot per unit requirement. I have 39 units. That's 39,000 square feet. My lot is 39,000 square feet. So that use has consumed the square footage of the lot by the area that's required in the lot. under this section, right?
Because there's some additional commercial use, right?
No. I'm just on, I didn't even get there yet. Just on the
Residential, right.
residential. The residential use is used all 39,000 square feet of the lot.
That's what it seems like.
The math says it does, right?
Yes, I agree.
Okay.
All right.
So no, and I just want, I want to walk through because I just want to, it's kind of simple, but it's also like, there's a nuance to it, right? So the 39 apartments consume all 39,000 square feet of the physical lot. They both uses meet it. Now I'm going to use 1,600 square feet of that lot for the commercial use. I don't have any lot left to use it. So that can't be cumulative. Otherwise, I'm out of compliance and none of these work on that. So what I believe, in my experience has been, is you take your 39,000 square foot tract size and you look at your usable minimum lot area per unit, in this case, 1,000. And that tells me I have 39 units. So I back into the apartments that way because I take my lot area, divide it by the minimum per dwelling unit. That gives me my 39 units. And now I want to put on 1,200 square feet of retail. So how, and that's where I was saying earlier, it comes down to how you configure the lot. I'm not entitled, I can put a maximum of 39 units on the lot, right? But if I don't have the drive aisles, the depth, the width, if it's in a regularly shaped lot, I may need to get variances. Or if I can't obtain the variances, then I have to do less units till I get to a number that allows the parking and everything else that's required under the Saladona zoning ordinance to be compliant. If I look at them cumulatively. So if I'm looking at the top cumulatively, I should look at the bottom cumulatively. If I treat them equal, then I have too much square footage attributed to both combined cumulative uses than the lot itself exists with. I need 40,600 square feet of lot area to get the combined 39,000 square feet of apartment use plus the 1,600 square feet of commercial use. And I'm short that 'cause I only have 39,000 physical square feet.
And back then we weren't treating the uses as cumulative. And that's how
I don't believe they were correct. I think it was does the multifamily use meet the minimum threshold of lot size, in this case 9,000 square feet, and we have 39, so that passes that. Now you do the math and divide the number of the dwelling size, minimum dwelling square foot per unit into the lot area to get the maximum potential units, right? That's our maximum potential density. We're not guaranteed that density until you can actually physically create a plan that it works with. And then you also look at the use of the 1,600 square feet of retail, which, as I said before, that has a whole different category of access for the building. Parking requirements are different for that than they are for the multifamily. So you have to look at all those factors: rear yards, front yards, side yards, access points, all that sort of thing. So I think my experience has been, is the lot big enough to meet the use? 9,000 square feet versus 40? Yes. Okay. Now take the actual lot area, divide it by the minimum square foot per unit, and that's how many units the maximum units I could potentially develop on the site if everything else works. That's why I don't think they were really viewed as a cumulative in my experience.
in the past.
In my
Right.
experience.
Okay.
Yeah.
I think I understand.
Does that make sense?
It does.
Okay.
Now you've reviewed the zoning ordinance in preparation for your testimony, right?
I'm familiar. I didn't review it in detail. I may not know the answer to the question you're asking, so I'll just let you know.
Well,
that.
that's the plan.
I know it is.
1318.02. I'm almost done. You've looked at that, right?
131802?
Yeah.
I have it here. Yeah.
Now, you would acknowledge that the 3 proposed townhomes are new buildings on the subject property, right?
Yes.
They're new buildings and they're new uses, right?
Yes.
And the zoning ordinance does have a provision that says that the word lot includes the word tract, right?
That was testified to earlier, I believe. Yes.
All right, thank you. That was illuminating. I have no further questions.
You have redirect before we go to the board?
Just briefly, Mr. Wagner Are you aware, what's the last date of these, the latest date on these?
It was December 14th, 2023.
23, and I believe the letter announcing this policy to me was dated April 21st. Are you aware of any zoning amendments or modifications to section 1318 between the dates of these plans and the letter to me dated April 21st? Are you aware of any?
I am not aware of any.
Okay, I have nothing further.
Good
I-
one.
yeah, I mean, I have, so like, I'm going to go back to my original point. Mr. Taylor denied it based on track size, correct? We can both agree, the new 312 Hanover, like that is,
Yep.
it is a track size issue. So we're like, in my mind, I'm ignoring the lot area in this. Like, I understand what you're saying with this point, right? But if it goes down to just minimum lot requirement, you have 9,000 and 2,000, that's 11,000. The lot area is 38,000, like that works. Correct.
That's correct. And my question, I don't want to.
No, yeah.
So the purpose of this is to show where is the line between what's treated cumulatively
Mhm.
and what's not cumulative. And I couldn't find that in the ordinance. So if we're going to treat the minimum lot area to be cumulative, or the track size to be cumulative to 9+2, then the uses should follow suit to be treated under the same cumulative basis.
Okay.
And the third example on the right of the sheet is the CS district, and that one actually fails both tests. The cumulative lot area minimum, which requires to put the apartments on 2,000 square feet per unit,
Mhm.
which the apartments would consume that whole area. And then the other use requires 2 acres. So that would be a 4.8 acre site for me to put 61 units and the restaurant. Regardless of the size of the restaurant, I just need 2 acre minimum.
Mhm.
So that was not treated on a cumulative basis.
Okay.
So it seems to be a lot of inconsistencies, other
Yeah.
than my experience, where if the use meets the minimum, each use meets the minimum requirement of the track size. Now it's up to engineer and figure out how can you get both uses on the site, because you're not entitled to put your maximum number of units and the other uses you want unless it's a viable development plan.
Yeah.
We can't.
I guess that's what I was like so in my mind, and I'm like maybe playing devil's advocate, but I'm thinking like, let's say there's a lot of 8,000, right? The track size is 8,000, and you have a
8,000.
building that already takes up 6,000. Like in your mind, you guys are like, well, I could put a 8,000 square foot track size building there because that's what takes up that building. It can't exist in reality, but in the interpretation of how you're seeing it, like you're saying, no matter what, I'm looking at that 8,000. So it doesn't matter that 6,000 is used. I'm going to put another 8,000 square foot in there because that's what I have to play with. It doesn't matter how many buildings there are.
Well, it's yes and no. So let's take your example. You have an 8,000 square foot lot,
Mhm.
and I have a use that requires 8,000 square feet. Call it a single family home, whatever,
Sure,
right, for
yeah.
example. So the single family home, or call it 6, the single family home needs 6,000 square feet of lot area.
Mhm.
And that takes up 3,000 physical square feet of the lot. Okay. The way my experience has been in the city is now I want to put a duplex on the lot, and that needs 8,000 square feet of minimum track size.
Mhm.
And it's going to take up 2,500 square feet
Mhm.
of actual physical footprint. So what we have done in the past is the lot size is 8,000 feet. It needs to be at least 8,000 feet for the twin. So that is a viable use on that property,
Mhm.
potentially. Now I have to look at the existing house that's on there. That's 3,000 square feet of the lot area where the house foundation sits. And now if I'm going to put a 2,500 square foot twin on, now I have to determine how that fits. Does it impede on the side yards, the rear yards, the front yards? Does it impede on the access that the existing single family home has on it?
Mhm.
I'm not saying I could put two 8,000 foot uses and have 16,000 feet.
Sure.
I'm not doing that. And that's why I said that the first part is, well, there's multiple parts, right? Is the use permitted in the zone? It is. Okay. Now, what's the minimum lot size? So does this lot conform to what's required for the single family use? It does. Does it conform to the requirements of the twin? It does.
Mhm.
Can they both coexist? That's where the plan has to be engineered to determine that it can meet all the requirements of the Saldo and the zoning ordinance. That's why it's a multi-step process.
Yeah.
And I'm certainly not sitting here saying, if I could put two 8,000 foot uses, I should be able to put 16,000 feet on an 8,000 foot lot.
Sure.
That's kind of what happened on these examples I provided here.
I guess that's where I'm coming back to, like, just saying, like, it's an interpretation, right? And in my mind, it's saying, like, well, we are interpreting that, like, you have 9,000 and you have 6,000, right? 15,000. That's the number we're working with. But there's only 13,000 square feet to work there. So in your mind, you're saying, well, I have the 13,000. So that 9,000 fits into that 13.5, whatever that number is. That 9,000 fits into there. So sure, it works. Now it's your job, my job, to make that building work within that property.
Right. Right. And again, it goes back to what's cumulative and what's not cumulative. Are
Do you
we
know,
treating?
and I'm this could be totally irrelevant. Do you know what the lot size is, like, behind that the property that's already there?
What's the physical lot of the existing 312 Hanover?
Yes. Like
It's
what,
a-
like to meet the requirements, like you have a backyard, right? Like where you're going to build and propose those townhomes, like what is that lot area? I guess
I have
like,
to look at the plan, but the lot itself is 60 by 224.
okay.
It's not being subdivided, is that, are you?
So that's what I'm saying. So it's not, it's staying one lot.
You meet all other requirements.
Right, in other words, is this the only issue? In other words, I think the answer to the question
Yes.
is that plan laid out to just, it's deficient on the item you've requested the appeal, but otherwise the zoning,
plan
there's
has
no
been
zoning
through
relief.
Site plan review, we've gotten a site plan review.
Okay.
letter. I think there's a potential deficiency with a driveway through it or something.
Okay.
Not anymore. But why don't you explain to where we are in the review process? This is our engineer, by the way. Please identify yourself.
Yeah.
Good evening. My name is Brian Spray,
I'm sorry, what's your
Integrated
last name?
Engineering.
Your last name again?
SPRAY, Spray is in hairspray. I'm with Integrated Engineering and performed the site plan. You're correct. The first plan that you put up on the board there was submitted, and there was a deficiency in the driveway width, which I discussed on the phone previously with Dave. And the new plan that you have shows it not being deficient anymore.
Okay. This is intended to go. I know this is somewhat in the abstract, but
Mhm.
I think what you're saying is we've done what our prior witness was Mr. Wagner suggested. We've now laid it out, and the deficiency is the interpretation that we're here on tonight.
That's
Right.
about right. yeah.
Okay. So we're clear.
I guess that's like what I go back to though, is like, that's what we are interpreting. It is the size and
Well,
we have no idea what, I was not on the board. So we have no idea what why these were approved, right? Do you have an idea of what the variance was granted for?
No, it's just, I was not involved with those. It was
Yeah,
just
I was not on the board. So, okay.
That was separate from the land development approval.
I
But it
think we're
was-
taking those for the example of his argument as to what the lot track size means
The
and how
inconsistencies.
1318.02 and the cumulative nature of that. His argument is, this is how I look at it, and it
Mhm.
doesn't seem consistent. And then we've got the current interpretation along with the issue of that was based on a changed interpretation in March. We all agree. Took away the
We are not saying that Mr. Taylor is from another planet. You
Right,
can't read it
right.
that way. That's not what we're saying.
Right.
Appreciate that.
Yeah.
It can be read different
Yeah.
ways, and what we're saying is the city has read it.
That
different
right.
ways.
Yeah.
That's what we're saying. They've read it differently. We're saying it can be read differently, and it has been read differently by people of a higher authority than us.
Yeah, and for the benefit of the board, in theory, I mean, yeah, the struggle with the interpretation sometimes is like these gentlemen said. It's imagine if we were trying to do this in the abstract without any actual explanation. Makes it harder, but by the same token, we're not here to analyze whether, oh well, because that variance was granted. That at the end of the day, this is just the interpretation. But I think what they've attempted to do is give you your explanations, but also give you concrete examples with what they offer and what Mr. Wagner and Mr. Preston offered. So
And I'd like to speak up about the examples. I understand the cumulative nature here. You've proven that very well with per unit. But here, I would have loved another example to that goes along with multi-use of the property, and looking at that with this cumulative use.
yeah, I guess the question is you didn't have any examples of where it was two different residential uses, correct? Your examples were not that.
It's all
No,
You
apart-
didn't find
it's
any.
all
I mean, they
apart-
are what they are.
Yeah,
Yeah.
I was going off my
No,
experience.
no problem. Yeah. I think that's what the question. Unfortunately, we don't really have an apple to apple.
Right.
But
But the same would hold.
whether it matters or not,
the
we
same,
would have to
the same
decide.
theory would hold true as to what's cumulative and what's not, and where
Yeah.
you draw the line. of
That's
how-
that's what you're suggesting,
That's
and the
what
board
you're
will have to
suggesting, but it
decide.
would have
Right.
been.
And you're saying it's not apple to apple because it's a retail.
Well, the question is it apple to apple, right?
Exact-
Because
exactly.
because these examples are retail and multifamily. I think that was the question.
Yeah.
The board needs to decide that, but they're saying they do not have an example that is both uses are residential, correct?
We do not, but 131802 does not make that
No,
distinction.
I don't disagree, Mr. Brett. Right. I just think that was the question.
I
Yeah,
got
that
it.
was
And
my
that's
yeah.
correct. We don't
Yeah.
have that.
Then that's fine. It is what it is. It may not exist. Who knows?
I think if we'd have started before last week, we'd have found out.
Well, it certainly probably doesn't exist to the scope of a major. It could be another one with 5 total units. Who knows? But
Understood.
we will not know.
But it's still two separate uses.
Yeah, it's two separate. Right. Yeah. I've got.
I can go back and try to find
Uh,
out. but
yeah.
Maybe I'll do that in my spare time.
Okay. Do you
Nothing further.
you have nothing further?
Mr. Wagner, and I think
Did we
I'm done.
Did
Any
we
other
ask
questions?
the audience for questions of Mr.
I did
Wagner
not.
or any more from the
Oh,
board?
we got questions from the audience.
Okay. Yeah, and same thing before, and you did a great job, focused on the testimony he gave.
Hi, it's Mike Pipestone again. I can spell that and give you my address, or we can go back in the record for it, whatever you prefer, ma'am. Thank
He
you.
doesn't need to do it again. Yeah,
Okay.
presuming it didn't change in the meantime.
Nope.
Either thing, right?
So, Mr. Wagner, you had said a number of times that this gets back to a cumulative versus non-cumulative interpretation, but then you also mentioned that you couldn't find the words cumulative or non-cumulative in the ZO. Can you clarify that for me?
I couldn't find in section 131802 where it says that that the uses should be accounted for cumulatively. The word cumulative, I may have misspoke. The word cumulative may exist if you do a word search in the zoning ordinance. It may be there. I didn't find it relative to 131802.
I did a word search. It comes up 6 times, all in related to floodplains, accumulation of water. There is no cumulative or non-cumulative interpretation anywhere else in the ZO regarding counting square footage. So can you tell me where you came up with that concept if you don't have a law degree and you just have a BA in economics and finance?
If the cumulative nature came out of the letter that says you have to add the uses cumulatively to the tract size, which is what I think this letter says. So if they're being added cumulatively, then why wouldn't the uses within that lot be added cumulatively? They're either being all being treated cumulatively, or they're not being treated cumulatively, or there's somewhere in the ordinance that provides a distinction for what is cumulative and what is not cumulative.
But this letter that we're kind of harping about that Mr. Taylor wrote was a letter you were not aware of prior to all of these projects that you mentioned that were approved prior to Mr. Taylor's election. You had that idea about cumulative use and non-cumulative use. Where did you come up with that?
I don't understand what you mean. Where do you? What do you mean? I don't understand.
You
your
said
question.
your understanding of cumulative comes off of the letter that we're talking about, that Mr. Taylor wrote, that 9,000 plus 6,000 equals 15,000 that we do not have at the lot that's proposed.
Mhm.
But your examples of non-cumulative counting of square footage exist prior to Mr. Taylor writing that letter. Where did you
No,
come
they-
up with
they
that
don't.
idea?
They don't.
So then how did you come up with this idea?
Because I read the letter and I tried to do an analysis, both reading it the way he says it and carrying it through and then doing it on the non-cumulative. This was done in the past 24 hours. This wasn't done in 23 or 21. This is specific to this issue.
Okay.
So you're saying is your question, did I do these in 2023 and 2021? And if so, how did I come up with that premonition that there'd be an issue of cumulative versus non-cumulative?
So what you're telling me
I'm
is,
asking you, is that your question?
my question is, where did you come up with this concept? And what I
From
hear
the
you,
letter.
okay, and what you're telling me then is that you just had no concept of it prior to Mr. Taylor. Cumulative or non-cumulative, that was not something that you were thinking about in these other projects.
Correct, because my experience has not been, it was not treated on a cumulative basis. As I said earlier, if you look at a use on a lot,
Mhm.
you look at what the minimum tract size is for that use, and then you do the next step, which is what's the area I can put of that use on that tract? And then can I engineer a plan to support that? That's what I've done for every development I've worked on.
But you also are a developer and not a person with a law degree or any history of sitting on like a zoning board. You do not have expertise in this field, as we have said earlier.
That's incorrect.
I believe we said that you're not an expert witness here.
No, you just said, I'm saying your statement is incorrect.
Yeah, his
Okay.
testimony is offered for fact
Yeah,
testimony.
and
So
I'm
the
also,
board's not
and
taking
I've
him at his
also
word.
been on the Williams Township Zoning Hearing Board for about 15 years. I've been the chairman for about 10 years. So I have a
Thank
little
you.
bit of zoning knowledge outside of my professional capacity as a real
Thank you.
estate developer.
Second line of questioning, do you have any a priori challenges to the interpretation that Mr.
Any what challenges?
A priori, it's a basic legal philosophical argument. Can you look at the interpretation Mr. Taylor has written and just on the words that are in it, without any examples of a building that's been approved or is already standing, just on the facts of the matter of the letter, can you challenge the logical nature or the rational nature of it?
Yes.
Enlighten me, without using any examples from a building that's already been approved or standing.
Okay, so you want me to answer, challenge this letter without using any of my knowledge or experience or history? Then, yeah, no, I don't have an answer to that question.
I think that's kind of my frustration and the frustration of all of us sitting here. We're being asked to look at a single letter, a single interpretation, and all you're bringing to refute it are, well, somebody else did it differently in the past.
Just
So
real
this
quick,
is the way I've already
Mr.
done it.
Pipestone. Questions 1 and 2. I understand that you're passionate and you care, but he's a witness here, and he's not acting against you. I feel like you're taking your frustration out on him, and I don't appreciate it. So just tone it back a little bit. You can ask questions, but there's no need to bring it that way.
Thank you, Mr. Chairman.
I'm done. Thank you.
Thanks.
Okay.
We still have another hearing. Okay.
Any other questions?
Yeah, I guess that. Oh. Okay.
Hello. Diana Rodriguez, 315 Rouge Street. I was not going to bring up this question because I'm doing my very best, I think, as everybody here, to just redirect comments and questions to the issue today, that is reinterpretation. But then I saw that there were some comments that are not so much about the reinterpretation we're dealing today. For example, asking if besides the lack of track, there are no other issues with these plans. So since the question was brought up here already, is our understanding right now, we just learned today that there's been new plans that have been submitted And we were wondering about that because to our knowledge, these plans have not been put like with the new details through the planning commission, nor does anybody that's gonna be affected by it have any knowledge of that. So I believe it was mentioned here that there were some changes to these plans. And here we are about to make a decision about a interpretation of plans that nobody have ever seen. So shouldn't that be reviewed again? That's my question.
Okay. Yeah, I don't think it's a question for Liz. Yeah,
Oh.
I was, what we were making the point on was the interpretation actually stands apart from the plans themselves. So tonight, what we were trying to say was you're not asking for any other relief on that plan. You're asking for an interpretation on that letter. So there's another forum. So let's presume this lot was 15,100 square feet so that it complied with Mr. Taylor's letter. Then that would be a completely different forum from the zoning board if they met every other requirement and we wouldn't be here. Point we were trying to make was they're designing this and doing that. They've asked for this interpretation, and that's all the board can rule on. We don't need to look at how large the area is where they're actually putting the townhouse. That's not relevant to the interpretation part. And there's another forum, which would be what I presume meetings at the planning commission, if this plan goes forward based on the interpretation. So sorry if that was confusing, but
No, I think
it's difficult for us to do this in the abstract, but by the same token, what the board needs to remember is we are kind of doing this in the abstract because it is an interpretation.
correct, but whatever decisions are made in the abstract are going to be applied to plans that nobody have seen.
Okay.
So,
Yeah.
and
Well, it's just whether the track size is met or not. That's all we're deciding tonight.
correct.
Plans would
It's-
need to
it's
get
a-
pre-approved, right?
There's
Mhm.
other approval
Process
processes.
to
Yeah.
get
Yes.
reapproved.
Correct.
Yeah, we're not approving a plan tonight.
I understand that, but we are,
Disapproving, whatever.
we are choosing to look at a question, whether this interpretation is correct or not, which is gonna be applied to this plan. That's gonna have definitely
Nothing
consequences.
we can do about the fact the way this
Yeah.
process works. I mean,
I'm
I
not
think-
questioning the process. The process
No,
makes
but I'm
sense.
saying you are. You're having to listen to this when there's not a plan. That's not the issue for tonight, unfortunately. I mean, they could change the plan 5 times after this interpretation. The board just has to rule on that. There's nothing more we can do because we can't require them to revise plans for this board.
Okay, thank you.
Yeah, sorry. I mean, I wish the answer could be better, but unfortunately, it's a different forum. Go.
Tammy Rinker,
Mhm.
402 3rd Avenue, Bethlehem. I was listening with interest all of the other sites where these buildings have been approved. Are any of those sites in the backyard of an existing house?
I think they might be the one, certainly on Union Boulevard. Well, Union
I
Boulevard,
think that that's a
behind it.
large empty lot, right?
It's a lot, but then there's some
Next-
houses behind it. Not, if you're, let's.
It's
if we're
not in the
talking about, Are they in the
backyard.
same context of the neighborhood you're in?
Mhm.
The answer is no. The 4th Street one may be. Linden Street is behind 3 other houses, and the condo says that it is surrounded by residential.
Okay, I did look them up online and it looks like a very different site than the backyard of an existing house. I also am curious if any of those structures were approved on an alley, because that Roush Street is an alley. So do we have access only through an alley?
Unfortunately, these questions are not relevant to the interpretation.
Okay,
I'm
all right.
sorry. I mean,
They're of my concern that it's in an alley, that it's in a backyard.
I don't disagree that that people will have concerns unrelated to this.
All right.
But Mr. Taylor, your interpretation doesn't rely upon the neighborhood or the alley location. It's not. It does in some instances, but not in this case. Correct?
Not in this case.
All
Okay.
right, thank you.
Yeah. Sorry. Still questions for that witness.
Yeah, all right.
Now, Mr. Preston.
I have nothing further. I would
Okay,
move for the
move
admission of our
A3 to-
exhibits.
No objection.
Yeah, they're admitted. Are you offering any witnesses?
I rely on Mr. Taylor's.
Yeah, I was going to say, I don't know.
Cross-examination.
Yeah, I think the cross did an adequate substitute for direct, Mr. Deschler. That was going to be my suggestion.
You don't want to hear more from me? I'm Eric. I'm terribly offended.
Uh, What do you want to do about the other hearing? Okay, that's fine.
We still have one more to get through.
Yeah, we
right?
do.
I need a
Is
break.
everybody going to go?
I need to go to the bathroom. Just need 2 minutes. I mean, how late do you usually?
We used to go.
I have to go back.
Okay, Moira needs a break anyway. Okay, we're going to take a 5-minute break. There were times when we used to go really late and we stopped at 10 o'clock.
It will be. It will be.
All right.
Good job.
So we're gonna, so here, I guess here's, well, by the time they talk, start deliberation, I guess we gotta talk to some applicant. What? Well, what we'll do is.
I'm not a lawyer. You just said it. I'm not a lawyer.
Traffic.
He was a little arrogant.
I'm not trying to be this. It's hard to understand.
Look at the pants he's wearing.
Yeah, we're gonna say since it's.
Looks like a wood spray.
Why don't you say
I knew that was coming. I said, I looked at Eric, Eric looked at me. and we went,
Yeah. We're gonna get them. We're, wait till,
Who is the other person?
I don't know, I'm looking around.
They keep pacing out there.
horse
So you want me to talk to them?
Well, where's Dave? I want to make sure we're good and he doesn't say we're stuck.
I would too.
Because if he does, then
He got no.
we'll just have to close this one and do the next year. Silence.
Yeah, it's fucking jacket.
Right? So here we're doing this. If for some reason we've got to do this.
I wish we'd gotten in is, what's the reason for this? Yes, that's the reason for it. You can't, so when you, this specifically talks,
Right.
This is also the second time that we.
it specifically goes to the line.
Yeah, we are.
So if
I've never seen that.
units in there,
No.
based on this big
It
lot,
says it on 3 acres, not 5.
Well,
You can't say
Right.
like,
no,
because that 2 is required.
to get that, yes, that's what it's there for.
This is the second time.
That's exactly what
It's the one that,
No, we're gonna let.
Oh, the next
And that's what they, how they've used
Yeah,
it.
the next one.
And that's.
This one, I thought that.
Well, we're gonna ask these people.
no. We're going to take their comments.
Well, you may end up putting
Next
all.
hearing, we'll listen to the comments, close the record,
This guy.
and then just not decide. This is going to take a while to decide.
We have some good talks.
The ordinance is in.
Yeah.
Who wants to go talk to us?
I don't think there's any.
Yeah, where's, what's his name?
I'm sorry.
I'm sorry. Okay. Let me see if
I would be so pissed.
He admitted it.
Should have put him first.
Do something.
Just keep doing this.
Doesn't matter.
We've done that before.
Yeah, just, didn't think about it. So many changes.
There was no amendment to the ordinance between his letters and the date of that other one. They didn't? Yeah, but there was no amendments to 13-1801. It was there before, it's there. Somehow, the rules have changed.
Don't just all of a sudden change. You might be right. In both directions.
Well, they hopefully will give us.
I really, it's all over like, why are you treating that issue?
As you speak with him? Okay.
Oh, okay.
Unless it says
You can't say one is non-king. I did one search. But you had set him up for that. You said, I didn't search the,
I answered the question.
I didn't do
I
it.
did search. Not relevant to this. Really? Thank you.
What's your point?
He doesn't want to reschedule.
He
said
sure
he
he
can
has
discuss
enough.
everything in 10 minutes.
blame
I know, he really,
No, I don't blame
straightforward.
him
I don't
either.
blame
like he
him.
sat through the whole thing. And
Yeah,
like,
that's right.
you know,
We do need to give him,
No, I get it.
and, is it cumulative or non-cumulative for the square footage?
I'm the worst person to be.
Yay, hooray, if we're gonna do this.
They want to get,
Jesus.
they start.
Closing.
Right, yeah.
Sounds good.
what
And
is?
then,
That helps us greatly, because what he's saying is there's a lot of stuff here that they don't quite get.
You got the pizza coming?
Hmm?
You got the pizza coming?
I can't even eat pizza.
Why?
I'm gluten free.
You are good.
I thought Dana was gluten. You're both
She is because I am.
because of you.
I actually have a wheat allergy, so but she just doesn't ever eat it because we never have it in the house. So
Like gluten-free pizza?
I'm about to order Domino's on it. Yeah, they have a gluten-free pizza. It's fine.
Doesn't mention trash.
They do. It's actually pretty good.
Is
When
it?
I was growing up, there's an age difference between you and I, pretty significant, because Domino's wasn't good. Like pizza.
Oh, I mean, it's not good, but it's like
But
it's-
they offer
gluten-free
it.
pizza.
Right.
No, but my children say Domino's is better than Pizza Hut. They're like, oh my god, my car. I was like, ew. When I was growing up, Pizza Hut was better than Domino's.
Yeah. At this point in my life, like any pizza that's like somewhat decent is like good pizza. It's like, you know, but
The land out there.
I'll have to make you gluten-free cookies that I
That's sterile.
New York Times.
You've got it. It's
Almond
got to stay.
Flour in it.
It is good?
Oh my gosh, some people.
Yeah, I think Lincoln.
yeah,
Really?
yeah. That's my mother-in-law. I always tell her, I said, you should
What's
open
that?
up a gluten-free bakery with how like she's so good, but
That's what that means.
it's
That's why.
Yeah, I
There's so many
They've always
better.
enforced.
The 1-to-1 flowers are so much better than they were.
yeah. Yeah, King Arthur or whatever.
And now-
it's like you can't even tell the difference.
Realize-
That's right.
Yeah, it was weird. I got
Well,
like very,
they do
very
very
sick.
well. They got
out of nowhere
residential
for, like,
podunks.
a
Where do they
year.
hit, where do they hit
I
this?
lost like a big ton of weight. I lost like
The
40
main-
pounds. Like I was struggling eating. Yeah, I went to the
Before you
doctor.
realized you had an allergy?
Mhm.
They
I went to the
figured it
doctor,
out.
like, I figured it out.
You
So,
did,
like,
by
yeah.
eliminating stuff or?
It was actually, I did all these weird tests and then I saw a commercial on TV of this woman that's like, every time I eat, I feel awful. My kids
I think that works, huh? What do you think?
same. And she's like, you should order this intolerance
Right, I didn't
test.
think
So then I went to a
I'm
tolerance
surprised.
test and my arm was like, yeah. And she's like, yep, whatever that is. Like, you know, and it
What's
turned out
up?
it was weed. Just like,
Oh, every day.
But- oh,
How about
that's
you?
put it out
wonderful.
and,
You
like,
came here for
3 weeks
support?
Later,
Plan found your way to my office.
amazing. Like the best I ever did. And I was like,
So ignore the old one.
swallowing all of these. Like, I got an endoscopy. I had like 20
That's
years
the
ago, I got an endoscopy.
So,
Like, what is
we'll see
going
who
on?
needs to talk.
Literally, it took like 3 weeks for my body to be
Close
like,
the
oh, you're
record.
not poisoning yourself every single
Like,
day.
You know, a memo
And like,
by.
honestly, I don't miss it.
You
So they're like,
can
oh, you
send
missed it.
them a
Like, you know, of course you miss pizza, but like, I
Yeah,
don't
just
miss
do a
feeling
memo
like-
and then we'll put you on.
Right,
something.
right.
Because
Like I was depressed because of how terrible
it's
you felt
complicated enough that
for a
Yeah,
year.
I
our deliberation is gonna go too long anyway tonight.
Prepackaged foods, non-alcoholic beverages.
They don't
Yeah,
have for
no.
reasons, but
People
how
don't
much
understand
longer?
that.
It's 4.5 hours.
Oh, I do, because I have little dairy issues, and so
Yep.
I know.
Yeah, it's not fun. It's like it tastes good for 3 minutes and then afterwards it's like the whole.
Yours is coming,
Right.
believe me.
I'm not doing
And before you knew, it's the worst.
it. I said to my doctor, I was like,
What date do you want to know?
I've lived for close to 30 years. I've never felt this bad. You know, and finally,
Because I just want to make sure everybody's here.
This is what you have. This is what is scheduled.
Okay,
I know, at least they didn't.
okay.
oh, they did. They tried.
They did?
Yeah. They're like, why are you going in anti-anxiety? I said, no, it's not just anxiety. Like,
Why don't we do this? Why
I don't
don't
want to
because
mask
we're just
it.
gonna
They have
do
that sound in
this
my
anyway.
Okay.
Could you mind just putting it on at the beginning of the 24th?
Look at that.
Okay, but let's make, can, we'll Will everyone be here?
I think of the Jason Isbell one. I know that that's not what you're referring to.
17th.
Remake of,
Okay. Everyone, because
I'll
then,
send it.
I am not, but I'm available for the one after that.
the 24th.
Mhm.
Okay. Are you?
17.
Okay. All right. 24 it is then.
Yeah, that's right.
Oh,
Yeah,
24.
Yeah. Okay. 24.
24
All, everyone will
I'm
be
here.
here.
Okay.
Okay. Perfect.
September, right?
September. Yep.
Yeah.
That's the regular meeting date.
Yeah.
Right.
You know about that.
Yeah. No, no. Yeah, because they'll give us briefs. I'll circulate it with my offices of it, and then you guys will just 24th. The first thing,
He didn't get to that.
you know, we can, if everybody's good, we can schedule it for 5, have an executive session, and then something like that. Yeah. Okay.
Open back up.
Open back up, and it just we'll take comment from the audience, limited to the issue, right?
All right, we're going to open back up. At this time, we're going to open it back up to comments from anybody that wishes to speak. One, just make sure you've been sworn in. If you haven't, let us know. We'll swear you in. And please make all comments in reference to the matter at hand, which is the track size only. Again, we're not trying to be rude. If you start straying off, we may cut you off to make sure you come back to the topic.
Yeah, we'll take your presence here as you have a concern with the project, but this board is only deciding that in technical interpretational issue of the track size in the April 2025 letter. Okay, so, and everyone's been great tonight, so let's keep it up.
Okay, I think I understand the assignment. My name
No
is,
pressure.
it's all right, back in school. My name is Samantha Cummings. I live at 314 Hanover Street. That's my little 2006 Ford Focus up there in front of the house. I had to sell it in January. Brakes stopped working. Okay. We've all been here. We've all heard the argument, but I couldn't miss an opportunity to make a comment. I think my husband can agree to that. And I don't have any additional numbers to give you, which I'm sure you're bummed about. I can't defend the reasoning for the way this was interpreted any better than what's already been said. But what I can say is that I'm a mom of 2 small kids, one of which is a new kindergartner in our neighborhood. I spend a lot of my time talking about rules, assessing rules, evaluating the application of a rule, thinking about the consequences of a rule, not following the rules, implementing rules. The required square footage for these 2 building types and the ordinance that we're talking about tonight wasn't randomly chosen by a mom at her wit's end on a hot summer day. They were written by people with a lot more knowledge about this than me, debated and adopted to protect the neighborhoods like ours from becoming overdeveloped or environmentally strained. And they're applied in the same way. And we've seen here that there are opportunities where a rule might be applied one way and might be requested to be heard a different way, and then it's heard a different way, and things might change. So history doesn't always guide us to the same spot, but what happens here tonight will change what moves forward, right? Somebody maybe 10 years from now will be sitting here talking about this case in reference to theirs. I think there needs to be a bit of reverence when we think about the rules that were chosen for the city. There's a lot of people here who care about our neighborhood, who care about this property, who care about my backyard, who care about the city as a whole. And the people who care are the people who wrote these rules and are the people who are applying them and are the city as a whole. I'm just asking that tonight we consider the people who live in this neighborhood, the people who want to live there for 50 years, the people who have lived there for 50 years. and who invest their time and their energy and their resources and their money into this neighborhood and this community and this city. I know there's different ways to look at a coin. There's two sides. And I think that, like I said, I can't make the argument any better to defend how Mr. Taylor interpreted this, but I hope that you'll just consider the people of this neighborhood as you make your decision. Thank you.
Thank you.
Hello, Diana Rodriguez. I will also do my best to stay in the school theme. We are all trying extremely hard, believe me, to stick to this very narrow question. We're not all lawyers. And I trust that if I deviate a little bit, you're gonna bring me back to the question, and I will always welcome the redirection.
It was even difficult for the lawyers sometimes, so that's okay.
We're all trying to understand. There's a lot of information and a lot of technicalities. So obviously, I'm here today to stand with the city with their fair and logical interpretation of Ordinance 13-1802. I believe this rule was created to prevent exactly the kind of overreach that we're seeing here today. And we are here presented with a question, if I understand correctly, and I think that question is whether this rule is being applied fairly. So I know that many are looking at that question and they think, wow, that's a very narrow question. I know that's been the emphasis of the night with a very narrow language, but there are real life consequences to getting an interpretation of an ordinance wrong. At the end of the day, and in the words of Mr. Preston himself from the narrative, what he's really asking here is a relief. That's what's being asked here, a relief from the interpretation that's been given from the expert on the city. And the way we interpret this today will set a precedent for the entire community for years to come. And I think what you said was spot on. Yes, there are words, there are technicalities, but we also need to work with the reality of where all this interpretation is going to finally be applied. I'm doing my best, and I do believe that everything I'm about to say is relevant, because whether this rule is interpreted correctly or not, it will have consequences for the group of people that was here and wanted to stay longer. These are the heroes who are still here, my goodness. And we set a precedent for how it's going to be applied in the future. And I think it's important to know, if you do decide to go one way or the other, how life is going to look in real life once you make your decision. So especially given the fact that we keep looking at back examples, right, to come back into the present. So today we have a chance here to set the right precedent for neighborhoods in the city in the future. And I'm not going to go back to the amazing work that the city's lawyer did. He did a brilliant job. And I'm kind of doing this because when I do the numbers and I read this ordinance, it all seems like so simple, right? Like sometimes I feel like I'm losing it. Like, okay, under section 130601, letter A4, the total tract size that required for both uses is 15,000, right? 6,000 plus 9,000. But here we have a tract that is only 13,408. Part of that is already being used. I don't understand how we can count it again. So that only leaves 7,409. That is not the 9,000 required. And then we see the language of this ordinance that have been read several times today, 13-1802, the lot area required for any new building or use shall not include any part of a lot that is required by another building or use. And something that I've learned from many people here in the city is that when you use the word shall not, that is an obligation. It cannot happen. And that seems to me like a no-brainer, but I do have to admit that sometimes when you care about something for too long, it's easy sometimes to lose perspective. So I like to remain open to different ideas, and I like to sometimes bring things back to the basis. And when that happens to me, I'm actually go to some of the wisest people I know, which happens to be my own students. They will tell me the truth. They will break it down to me. Sometimes they're way too honest. So I kind of wanted to like break up the scenario to them. Like I play it out in my classroom. I'm like, hey guys, I have this situation here. I have 13 apples. And you know what? I already used 6 of those apples to make an apple pie. So how many apples do I have left? And they're like, Ms. Rodriguez, we are so glad you're not a math teacher because everybody knows you only have 7. I'm like, well, that's a problem because guess what? Now I want to make an even bigger pie and that's gonna require 9 apples. Can I make that pie? They're like, no, Ms. Rodriguez, I'm sorry, but you're gonna have to make smaller pie. You cannot count the same apples twice. And that's exactly what's going on here. You cannot count the same land twice. Even a child can realize that, but I don't know, I'm like, maybe I'm missing something. That's why I like to bring it back to the basis. And I think anyone here in this situation will have to apply for a variance. Will have the humility to follow the laws and apply for a variance. And if you cannot accept that simple rule, you're not really asking for fairness here. You're asking for a special treatment. And you're really proposing to be above the law. And that, of course, is going to set a precedent of we've all been afraid here. What are we going to say to the city? From now on, tract size doesn't matter. Anyone, with the right lawyer, of course, can build anything, anywhere, even if the space isn't large enough. Of course, that's going to be a violation of 131802, but then we're going to undermine 130103. Isn't that the very purpose of our zoning code? Isn't that why we're here today? How can we claim to protect the public health, the safety, and the welfare of the people here if we allow for the ignoring of minimum tract sizes? That's such a basic thing. Of course, this is going to lead to overcrowding, traffic congestion, increased fire and flood risk, and the destruction of natural resources. That's what's at play right here. And that's why we're also concerned about this. The space is limited, and this is what happens when you don't have enough tract size. The math, it just doesn't add up. I just want to finish by saying, because I know everybody's ready to go home, but we are deciding here the rest of our lives. That's what's being decided here. There are words, there are technicalities, but people in this neighborhood knows what happens when too many reliefs are granted. Yes, today we're calling the relief a reinterpretation. Other times we call them variances, because when you have a variance, at the end of the day, you're asking for the relief. And in many cases, developers create self-created hardships to ask for that variance. But at the end, what happens is that there is an ordinance like 131802 that is supposed to protect a community, and that protection is being denied from us. And there are consequences. And we've been through that already. We've been through this kind of abuse before. And when this keeps happening to the same group of people, these reliefs are granted in the name of interpretations or other things over and over again in the same parts of the city. I'm sorry, but we are just increasing the divide between the parts of the city who can afford this kind of protections that this ordinance provide. They stay green and healthy. And the rest of us just keep getting more concrete, more heat, more pollution, and let's not forget where we live. We live in the Lehigh Valley. We're already ranked among the worst in air quality. So this reinterpretation today and having enough space matters because it affects our health directly. And I'm just going to finish by saying that we are not opposed to any plans, that might happen here as long as they respect the ordinances, that they have care for the community and that they follow the law. But at the end of the day, this is a simple rule. We've heard all kind of complicated stories that not always apply to what's going on here, but at the end of the day, the law is simple. You cannot count the same land twice, and ignoring that, it's not just a legal error, it will open the door to more damage, declining health, and deeper injustices, especially in RT districts. But if we honor it today, which I think is what the city is trying to do, we're going to send a message of hope and trust, which this city really wants to have, that rules apply fairly and that zoning laws still matter, because you know that in order to be able to protect the health, the welfare, and the safety of people, we really rely on these ordinances to be followed. So thank you so much. I really appreciate it.
Oh,
Okay.
Thanks, and I will be brief. It's Jefferson Pooley, P as in Paul, OOLEY, 331 Prospect Avenue, off of Rouch Street. I'll be very brief. I know we're all tired and ready to go home. I just want to echo what a couple of my neighbors have said, that, I mean, and I would even put it more strongly, that this alternative interpretation doesn't really pass the laugh test. I mean, if you just read the plain language of 13-1802, it would render it meaningless. Basically, you could triple, quadruple count on the same property. If you had, for example, like an existing non-conforming use that had 95% of the lot, on their reading, you could build townhomes on the remaining 5% on the basis of that 100% lot size. And I do think it requires Houdini-style gymnastics to come up with a reading of this kind. So I'll just leave that there. And I wanted to just say one other thing. In reference to the appeal itself, it was submitted some months ago and had what I thought of as a disconcerting confidence. It was very short. It said, and I quote, "The applicant believes that relief should be granted because the city's zoning officer applied this 13-1802 we've been talking about," and I continue to quote, "to the applicant's site plan in a selective manner, which seems tailored to a desired result rather than applying said section logically and consistently." And that was it. Just that insinuation with no engagement whatsoever with the ordinance, leaving a kind of whiff of wrongdoing or skullduggery. And I just want to put on the record that nothing in Mr. Preston's line of questioning or in any of the witness statements have revealed one scrap of anything but a city acting in good faith to apply the rules. Indeed, I would say that the very reversal of that original multifamily designation to the townhouse reversal of the city is Exhibit 1 in that, on that front. It gave this applicant what they wanted. So I don't want to get into the technicalities, but it's totally clear and is established in testimony today that this 13-18.02 issue, contrary to the insinuation in the appeal that it was somehow cooked up after the multifamily thing didn't work, only became relevant after the city's decision to reverse its position on multifamily versus townhouse. So I just want to register the bad odor that the appeal and its thinly veiled accusations have left. And I want to just acknowledge the unenviable position that Mr. Taylor, and in fact, all of you are in, where you're perched between animated, emotional residents like myself and developers, some with deep pockets to hire skilled lawyers like Mr. Preston, and just to thank you.
thank you. All right, anyone else?
Please.
Oh,
Yeah, we've heard that.
My name's Emily Brennan, and I live at 1126 West Market Street. And I just want to come out here and thank you all first for being here. And I just want to support Mr. Taylor in your interpretation. I want you to know that we are here to make sure that you know that we hear your interpretation and we support that interpretation. There's a reason why the ordinance requires the area of the other uses on the same lot are deducted from the calculation. If overturned, it would open the door to allowing much higher intensity developments than the ordinance intends. The neighborhood suffers from overdevelopment and a lack of infrastructure to support this overdevelopment. We have personally suffered this overdevelopment. Sorry, I hate talking in public. We recently had a traffic study done by the city 26,000 cars travel up West Market Street every single day. You can pull it. I have had 3 cars totaled parked on the street in the last 7 years. We already are crowded. We need to hold the ordinances where they are. If we start changing them, we will not be able to rein them back in. Thank you for standing your ground, Mr. Taylor. Thank you. We appreciate it. We see you. Please, I'm asking you, keep the ordinances the way they are. The interpretation is correct. Thank you.
All right. Anyone else? All right.
Okay. All right. Gentlemen, what I'll propose is we're not going to get to be able to give this the correct amount of deliberation that it would need because we've got another hearing after this. So we will close the record. You can, by the end of next week, submit a brief memo with your legal analysis. If you will waive legal argument tonight, we'd appreciate that, and submit it in writing. And then we will reconvene and deliberate. September 24, we'll issue a decision.
Memos due September 5th. Am I right on that?
Yeah, next Friday, right?
All right.
Yeah.
Friday? Okay.
Yeah.
You got it.
No,
No objection here to.
Okay.
And should we submit them directly to you, Mr. Schock?
Yeah,
Okay.
submit them to me, and then I'll get them to Mr. Taylor, and we'll circulate it to the board, and then that would still give us. Do me a favor, then. Let me just pull the calendar. Let me just do the math on the 45 days. I may just ask for a couple of extra days. The decision. That would be October. Yeah, just give me an extra 2 days on the decision to the 13th then. So the 45 days would be October 11th, Saturday. Monday, October 13th, we'll have the written decision out. Sound good?
Yes.
Okay.
Yep.
Good, Mr. Deschler?
That's fine. I was just in my head. So we're not going to come back to keep like the record open for any reason to extend the time that you might have to do the written decision. We are closing.
No,
hearing tonight. Okay.
yeah, I don't want to keep the record open. I think I just want to end it tonight, and we're fine because that'll be 5 submit, 24 the board will render the verbal decision, and that still gives 3 weeks to get the written decision out. That won't be an issue,
Okay. Understood. Yep.
right? Yeah. Keep the pressure on me to get it done. It's fine. Yeah. You don't need to be kind to me. I'll take care of it. Thank you, though. Yes.
We have a community petition. We would like to have it on records, if that's okay.
Any objection?
I didn't hear what was said.
They have a petition. Do you have an objection?
No objection.
No.
No objection.
Okay, we'll take it. And generally, we admit these for recognizing for what it's for the value that it is. That's fine. We'll make it community exhibit 1.
Okay.
Yeah, you'll need to bring it up. Yep. Hey, thanks.
All right.
And I will scan this and send both of you a
appreciate
copy.
that.
You got it. Unless you'd like to look through it tonight.
No, that's all right.
Okay. Okay, that's it. And then everyone in the audience understand what's happening? Okay,
Permission to leave.
permission to leave. Pardon me? You're welcome to come back on the 24th for the announcement of the decision. You are not obligated in any way to do that. Then there will be a written decision issued by October 13th, which you can request a copy of from the city. Or if you signed up on that list, Mr. Taylor sends them out, right?
Correct.
Yes.
Okay, so we'll get an email.
No, it depends what you put on the list. Is it-
Oh, okay.
On the-
Address.
yeah.
All right.
Yeah.
Thank you.
Yep. See you guys. All right.
All right, next one up. Can you hear?
I live on Prospect, so I know it. Yeah, I appreciate you guys. What's that?
All right.
Yep.
Yeah,
Here we
no,
go. Next one up.
Yep.
1225 North New Street.
Take glasses on.
Good evening, everybody.
1225 North New Street. And I'm going to apologize if I misspeak your name. Applicant Iftikhar Ansari seeks a special exception to convert a non-conforming personal services use salon to a non-conforming retail use. Sections 1304.01A, 1325.07, and all associated variances, special exceptions, and interpretations.
And before we get started, can someone confirm when the property was posted?
The placard was on. The date the placard was on. No, the date the placard was on.
Oh, August 15.
I'm sorry, I didn't hear.
August 15.
Council, can I have your name, please?
I'm Mubashir Ansari.
I have it then. I just want to make sure. Thank you.
Just before I get started, do you guys have a copy of the site plan that we submitted?
They do. It should be at the back of your packet.
Okay.
Sure.
Yeah. Can I ask, not the video, are you
Yeah, I'm an attorney.
You're attorney also?
And this is my father.
I was about to say, because the last name, I said, well, I better ask that. I thought you were a
I
lawyer.
was going to disclose
You
that.
projected lawyerness very well, but then when I heard the last name, I wanted to make sure.
No worries.
Thanks.
So, good evening, members of the board. My name is Mubashir Ansari, and I'm here on behalf of the applicant, Mr. Iftikhar Ansari. My father, who is the equitable owner under agreement to purchase 1225 North New Street. His purchase is contingent upon zoning approval, and we have submitted the affidavit of consent already from the current owner that we have submitted to the board already. We are requesting a special exception under section 1304.04A of the zoning ordinance for reuse of this corner lot as a neighborhood convenience store. Based on public records, this property has continuously operated commercially since 1945, most recently as a beauty and nail salon. The proposal does not involve any expansion of the building footprint or major exterior changes. The building will remain one story with only replacement of windows and doors and refacing of signage. Parking exceeds ordinance requirements, and no tractor trailer deliveries will occur. Mr. Ansari has over 20 years of incident-free experience successfully operating convenience stores throughout the Lehigh Valley, and he intends to run this store in the same professional, neighborhood-friendly manner. With the board's permission, I'd like to present Mr. Ansari for testimony.
Yes.
Mr. Ansari, please state your name and address for the record.
Yeah, Iftikhar Ansari, 4438 Stony Brook Court, Allentown, PA 18104.
And do you currently own the property at 1225 North New Street?
Not yet. It's under agreement and approval by the zoning.
Could you repeat that? It's did you mean it's contingent upon?
Yes.
Okay, good. Thank you. And can you briefly describe the property and its historic uses?
Yeah, it is a corner lot of a beauty salon and has been used commercially for decades, since at least 1945.
And what are you proposing to do with this property?
To make a neighborhood convenience store.
And what products are you planning to sell?
What's mean?
What products do you plan to sell there?
So just like dairy products, drinks, snacks, grocery, tobacco, and lottery.
And do you plan to accept food stamps?
Yes, just like other small neighborhood stores.
And what do you plan your hours of operation to be?
7 a.m. to 9 p.m. by the zoning approval.
And how many employees do you anticipate hiring?
2 to 3, one part-time employee.
And will there be any tractor trailers making deliveries to the property?
No tractor trailer delivery.
And how do you plan on having deliveries made to the property?
Just minimum deliveries. I have my own wholesale business, and mostly deliveries handled by me with the Ford van. That's minimize traffic impact.
And will your proposal require any expansion of the building footprint?
No expansion and no new construction.
What exterior changes do you plan to make, if any?
Just window and door replacement and the signage update.
And how many off-street parking spaces are provided? And does that meet the?
We have 6 spaces. Ordinance required 2. We are more than the exceed limit.
And do you expect traffic and parking impacts to compare with the prior salon use?
No, almost the same or less.
What steps will you take to minimize impacts on the neighborhood?
It will be like easy necessities for neighborhood.
And will you have an enclosed dumpster on the property?
Yes.
Is there going to be any sound being amplified inside the store? If you're going to have lighting outside the property, what time do you plan to shut it off?
Before 10 p.m.
And I think we touched on this earlier, but what time do you think the deliveries will be made?
Deliveries in the morning.
And could you just describe your experience operating convenience stores in the Lehigh Valley?
Yeah, I have over 20-year experience in convenience store business in the region.
And have you ever had any violations for any of your stores?
Not even one.
What benefits will this store provide to the surrounding community?
Yeah, it will be very beneficial for the neighbors to get the basic stuff.
And if the board imposes any reasonable conditions, are you willing to comply?
Yes.
Okay. So Mr. Iftikhar has testified that he is under agreement to purchase the property with the owner's consent, and that his proposal continues the longstanding commercial use of the site without expanding the building. The project meets or exceeds all zoning requirements, provides sufficient parking, avoids tractor trailer traffic, and will keep the property's appearance essentially unchanged aside from updated windows, doors, and signage. Of course, with the zoning board's approval about the signage. This testimony establishes each of the criteria for a special exception under section 1325.07. The use is consistent with the ordinance's intent for reuse of a corner lot. It is compatible with the neighborhood. It provides more than adequate parking and access. It will be avoiding traffic congestion. And it serves public welfare by offering daily necessities, jobs, and tax revenue. For these reasons, we respectfully request that the board approve the special exception.
Board have any questions?
I just have a quick question about the interior. Do you have to do a lot of remodeling since it was a
yeah, they have a little bit. It's not a lot.
Okay.
Because bathrooms remain the same, office remain the same. The other area, little modifications.
Okay, thank you.
Are you going to have any seating inside?
No.
And when it comes to lighting, it says that any lighting shall be limited to hours when the use is open to the public. So the lights will be, this one says limited the hours when the use is open to the public. So I think your lighting here said it would stay open till 10, but I think the ordinance requires during business operations, which would end at 9.
Okay, 9 o'clock. Yeah.
And then all signs must, let's see, no new sign shall be internally illuminated, right? So
Yes, no new one.
what type of sign do you anticipate?
They have already beauty salon one, so I just replace on the wall.
Okay. And would you agree to the trash considerations as outlined in this ordinance, which are one of the reasonable requirements would be that the operator use regularly collected litter, that you regularly collect litter on the sidewalk and gutters at the edge of the street adjacent to the lot. So keep the property tidy and make sure that there's places for when people come out, they can throw their coffee cup away there and not on the neighborhood
Right.
streets. Okay. And I saw your other store on 7th Street. It looks nice. I always worry about the preponderance of smoke shops here, so I'm hopeful that this store would have that same community character rather than a vape shop.
Yep.
You know? Okay. Thank you very much.
All right, thank you.
All right. I think, any questions from the audience? Are you sworn in? All right. Yeah.
Raise your right hand. You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear or affirm?
Yes.
Thank you.
I was just here because I was curious about zoning, but then this came up and it's near my house, so I have some questions. My name's Catherine Grasso. I live at 55 West Greenwich.
Sorry, could you say your last name again?
Grasso, Grasso. I'm just curious, one, like procedural. Can I ask you guys questions? Or just here?
Right now, you're asking the witness questions.
Oh, okay.
Sure.
As far as the conclusion about the traffic being less than a salon, what evidence do you have for that?
What's the evidence?
So like the way that I think of it is someone who's using a salon, they go in, if they're getting their hair cut or hair dyed, it takes a couple hours, like that car's going to be there a long time. A convenience store, someone's running in to get like cigarettes or a soda, it's quicker. So I would think more traffic. So I'm just curious, you drew the conclusion that you thought it would be the same or less based on what evidence?
Mostly, I have, as my other experience, mostly my stores runs on the local surrounding neighborhood.
So people walking.
Correct.
Okay.
Like buys milk, eggs,
Yeah.
cheese, soda, just like that.
Is there
Yeah. It's
evidence
not
within
like,
the
it's,
surrounding?
traffic cause people come.
Yeah.
Mostly like my neighbor,
I'm sorry.
local neighbor.
You got to speak to the mic.
Mostly like local neighborhood, my customers.
So walking
Correct,
typically.
walking.
Okay. Did you do any, I'm just curious, research about like the need in the area? I live in the area and generally I do my grocery shopping at a grocery store because it tends to be
Yeah, I
more
checked.
cost effective.
Yeah, check. They have a lot of houses and they have two corners. They have pizza store and subs. So definitely they need to play lottery. They need drinks, different kind of variety drinks.
Okay.
And snacks. So.
Okay. I guess my other questions are for you guys because they're more logistical. So I wait.
Yeah, I mean, I just go ahead and ask them because normally the board is not open for questions.
Oh.
Yeah, the board doesn't answer your questions. But
Okay.
if you want to ask a question about the process.
Yeah, I'm just interested
Well,
in the
I'll be
zoning
glad
board.
to-
So
Oh, sure.
sorry. Do you guys have to go and see these spaces in person to assess?
No.
No. So we're just going off of pictures.
Yeah.
Okay. Second question, is there the possibility of a stipulation of, I have the same concerns about the smoke shop thing. Is there a possibility of a stipulation of like limiting or removing tobacco sales?
The board can consider that as a potential condition. I don't know if they will or if they would impose it, but theoretically, anyone can propose a condition that is reasonably related to the use, and the question would be, is that a reasonable restriction
Sure.
on a corner retail store?
Sure. So it would have to be a proposal coming from the board, not from someone.
No, you at the end, you'll have a chance to talk.
Okay.
You can do that
Thank
and
you.
suggest a condition.
Thanks.
Right.
I'm learning.
Sure. You know what, ma'am, I missed your name. What was it? Catherine Grasso. Thanks.
I need to be sworn in. Sorry.
Right hand. You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear or affirm?
Yes, to both. My name is Annalisa, and the last name is hyphenated. Kelly, Kelly hyphen Cavotta. And I live at 12 West Elizabeth Avenue in Bethlehem, which is right across the street from the salon. So I live 4 houses down from Carl's, and I'm across the street from Fratelli's, the pizza place. So I have a question for you regarding when you said that you were going to have smoke shop.
Not smoke shop,
Okay.
convenience store.
No, I understand that, but like you said, you're going to have tobacco in there,
Yeah.
correct? Is it just cigarettes?
Yeah.
Are you going to have vaping things there?
Whatever states required, it's not like whatever state required, they give us permission to put it, I put it.
Okay.
Yeah.
I have a concern about that because we have
But it's not smoke shop.
No, I understand that, but we have a vape shop up the street at the Dunkin' Donuts, and we have kids all over the neighborhood. So that's one of my biggest concerns, which I can voice later if you like. But the other question was about the traffic, which is horrendous in that area. That traffic light, that intersection, we see accidents at least once a week. So when you said that you're going to have off-street parking, because to me, off-street parking means that they're not parking in that parking lot.
Oh, no, we have inside parking. We have
Okay.
6 parking spaces.
Okay, so
Inside the parking, inside the property.
the lot. Okay, so 6 parking spaces.
Correct.
So again, we have Carl's, we have Fratelli, which they have nowhere to park except for on the street. And then now we have the possibility of this convenience store. And then residents like us who live across the street, we end up having no parking spaces.
And just real quick, Mr. Taylor, these guys aren't asking for parking relief. They meet the parking requirements.
Yes.
Yeah, so just so you realize, when the off-street parking means your own parking lot, they presented a plan that I think has 6 spaces. So that meets the minimum requirement for the city for off-street parking spaces, meaning not using up the city street spaces.
Well, that's going to be impossible. I'll just tell you that. Can you bring up the picture again for me, please? If you can, of the shop?
The photograph.
The photograph, correct. So when you look at the lot, how do you plan on doing your parking spaces?
It was on that plan.
Yeah,
that
it's
was
on
up
the plan.
before. Yeah, there, right? Does that shows the parking?
1, 2, 3, 4, 5, 6.
Okay, so
And 1 handicapped.
so 2 to the left, right? So one of them is going to go where the garbage dumpster is right now? Am I seeing that right?
I missed.
So the handicap is on the side of the building. And then the one next to it is where there's currently a garbage dumpster. Okay. And then you're going to have 4. So, and you have 3 entrances to this place. Are you going to have a designated like one way
Yeah.
in and out?
Yes, that's what they shows.
Okay, so they're only going to come in that way.
Correct.
Okay.
And those spaces, according to the zoning officer, do meet the ordinance. So we can't require anything more than what the ordinance requires. So, correct, Mr. I mean, that's more, and you checked them and the spaces are compliant.
Yeah, I just have
Yeah, I mean, you can have your opinion about, I'm not questioning that. I'm just saying the city has an ordinance.
right. I really wish.
Or we need to go by the ordinance.
No, I understand that. And I just really wish that there was more of a study done in that area because we've asked for that for so long because there are accidents all the time. All the time. So, I think that's all I have for now.
Okay.
Hello, my name is James Talarico. That's Talarico. I've been sworn in already. I'm at 1226 Lorraine, which is your nearest neighbor. If you could bring up the picture, please. Those arborvitae are mine. My garage is right there. You can see to the left. No. Yeah, right there. That's my garage. It's a two-car garage right in there, which faces the property's edge. So I've got a few questions for you. Nice to meet you. The plan, and if you could bring that up, please, again, the plan behind the building, am I seeing that correctly, that the property line is that dotted line? Right behind the building? Yep. Okay. For you to have those spaces, the handicap space, the planned refuse box in, and also the other additional space, you have to remove, and it's not shown here, about 15 feet of what is now, I think it's grass, and there are some very large arborvitae trees there, cedar trees. I think 3 on your proposed, purchase. Those trees would have a major impact on that parking that you have there, because there is a retaining wall. It's a very short one. It's only a foot high, but it's what separates, if those trees go right into the retaining wall of my neighbor Kyle, who would be right behind your property. How do you propose removing those trees, putting in the spaces, keeping the retaining wall, it's very delicate, it's very tiny, because then there's a 1.5 foot drop to his driveway, directly into his driveway. So there is no wiggle room. What are you planning on doing behind there? In other words, are you going to put up a privacy fence in addition to the refuse fence? Because it's a drop right down into his driveway.
Okay. Maybe I put a ballard in there, or car stop before to hit the car?
No, I think I worded it too, it was too long a question, but there are some very large trees there.
Okay.
To do this plan, you have to remove about 10 foot of trees and repave. You're going to have to put up
Aerial.
no, it's the other view. That's the wrong side.
Why don't we do an aerial if Mr. Taylor has it?
Yeah.
These 2 trees.
You can pull in.
Now, do you see those trees right there?
Yep.
And the grass?
Yeah.
That property would be part of this proposed purchase. And if you notice right there, it drops right into, after a little retaining wall and a curb that's built into the next property. There is no buffer zone. If you remove those trees to execute this parking plan and the boxed in area, you're going to have to rebuild that area and repave. Have you considered that?
Yeah.
Okay. Also, you are committed to a one directional only entrance?
Yes.
And the egress would be one directional out on New Street?
Correct.
Because part of the big problem, and I'm sure my neighbors would agree, that little alley, it's a busy alley, but that corner, the New Street, North New, and Elizabeth Avenue is a very difficult corner and it's very,
Right.
very busy. So entrance from Elizabeth only.
Correct.
Egress out and exit onto New Street
Street.
only.
Yep.
Okay. So there would not be two-way traffic.
No.
Because that's important. So you would
Yeah,
have
because-
signage, that says no exit, entrance only.
Yep.
You could put those in?
Yep.
Okay, and I know that we have a family neighborhood. My neighbor Brian has children, other people have children. They play in the alley. So it's very important that traffic doesn't increase. And to affect that, I don't know, maybe this is a city question about a one-way only, but Radley Street, which is really not a street, it's a 14-foot wide alley. All our garages are on there. Nobody has a garage on Lorraine or on Elizabeth. And as you've heard, other people have parking problems. So for me personally, getting in and out of my garage, that's the only place I can park. And anything that increases the traffic would be very, very detrimental, and especially pose a danger to the children in the area. So my big concerns are, I'm really happy that you have a 9 o'clock closing and 9 o'clock lights out. But I'm not happy about, the possible entrance in there, unless it's purely, if it's really well marked and there are arrows painted, entrance only, exit only on.
That's what I plan.
Otherwise, people are going to be using that alley, and it's going to be a mess.
Agree.
Okay.
Also, I have one other quick question, and that is about the possibility, and we've experienced this we've all experienced this during Moravian College home football games or Liberty High School games or just in general. There's always, yes, there is foot traffic, but there's also a lot of people that come in for these games and it becomes pretty chaotic. So it's important that parking doesn't become impossible. And I share their concerns about it's really tough right now. So if you can have managed to do those, that's a big project, those trees and that excavation. Well, maybe it would work. My wife had a question for you.
Okay.
So she can't be here, but she said, is it possible that if you put a privacy fence in the back to make it clear that nobody goes over those
Okay, that's makes sense.
those and drops into Kyle's driveway, but also that nobody hits one L-ing around the side to a degree would be helpful. So nobody hits the stabilizing line for that telephone pole, which I will say I've seen, and as I can see right out my back, has been hit many, many times by a garbage truck. The whole pole shakes. And finally, the garbage men took a different route and they didn't use the alley anymore, and that was resolved. But those are my concerns, and in addition to what my neighbors have as well. So if you can address those things,
Sure.
especially make my wife happy. And
Where are your dumpsters going to be going?
It shows. No, that's loading
They're
area.
going where the trees are.
Are you putting it?
Here, on this corner.
Is that it?
Is that square your dumpster, or is that your air conditioner unit?
I think so by on the New Street side next to the building, they have some empty space.
Okay,
On the New Street side, you said?
Yeah, yeah, just like here. Yep.
okay. All right,
And you would put a fence around that.
Right.
yeah.
They're asking, would you put a fence around that?
Yeah, if my neighbor happy, so definitely I put it.
Where's, I thought the dumpster was going in this. Next to the handicap. Next to the handicap?
No, other side.
Okay, well, only one person can talk at a time. And if you're going to ask questions, you got to go up to the mic. So is the question, where's the dumpster? Okay, can you tell us where the dumpster's going?
Yeah, I show up there where he put his scroll. Yes,
Okay.
right here.
All right. That's an air conditioning unit next to the handicap spot, apparently.
Where is it going?
Right here.
Where the cursor is circling.
Right here. On news.
Okay, so that's not going to be enclosed.
It will be enclosed. It'll have to be enclosed.
Yeah.
Privacy.
Okay. I don't see how there's room for traffic to flow out there if you have that enclosed on that side.
No, they have enough space.
I don't know. And then what is that other area that's on the plan?
It's an air conditioning.
What is that grade in? No, that whole grade.
That's giving for a handicap loading area.
Oh, okay. Okay, so that is not the dumpster. Okay. Okay, thank you.
Mark Harris, 1204 Lorraine Avenue. My house is on the alley that backs onto the property there. Hi, nice to meet you. Thank you for coming here.
Sir, can you give me your last name again?
Yes, Harris, Harris, 1204 Lorraine Avenue. So just to be clear, are you going to be serving food?
No.
Okay, so there's going to be no fryer or
No
no
fryer.
grill. Okay. All right. I guess this is a comment around a question. You keep referring to this as a neighborhood convenience store. And I like the idea of the old-fashioned convenience store around the corner where you could grab things. Those were in largely, well, I think even where we are now, there were convenience stores on the corners in some of the stores that are there now. So back in the 1920s and 30s, that's what they were. So I like the idea of having something like that. The issue that I see with it is that we've got a really small building, fine if you want to have a convenience store there, but you have 6 parking spaces. So it's not really going to be entirely pedestrian since you have those parking spaces. So you are going to have to accommodate cars in a place. You've got 6 spaces there, but you've had 2 previous tenants there. You had a real estate agency, single realtor, and you've got a salon that's had 1 or 2 cars parked there at most. The lot is mostly empty, right? So we haven't had any real traffic concerns because of the existing use of the property. What worries me is that you may draw some neighborhood traffic, but you're also a foot traffic, but you're going to draw car traffic too. You're at the intersection of 2 of the busiest streets in Bethlehem. And I can imagine people driving down New Street wanting to turn into your property with a traffic nightmare in front of your store. So maybe some of these people will end up going down the alley, which for reasons for living so close there and having neighborhood kids who play in the alley, I'm not too keen on that. And I think you may end up.
So just, I don't mean to cut
Yeah.
you off, but you need to ask questions. There'll be
Yeah,
time for
sure. Okay,
comments later.
sure.
Yeah.
Fair enough. So are you sure that your parking, as you have it configured now, is going to be able to accommodate the traffic that will be moving in and out of your space that's not foot traffic?
Yeah, that's this is one-way traffic, so they cannot go back. They cannot go back to the alley. Once come in, they out from New Street.
And just real quick, just he is not asking for relief for
Yeah.
parking.
Yeah.
Correct.
And I understand that he's already got the parking spaces here, but I'm just telling you, this is an extremely busy corner where there are a lot of accidents on the corner. You're already having to make accommodations to get people in and out and make sure they go right. And I think that you may be setting yourself up for a lot of congestion there and for perhaps aggravating a traffic issue. Can't do anything about it, but I just want to go on record as saying that this could potentially be an issue.
I will
because
try
this
my
is not-
best to put as much sign I can put.
Yeah, yeah. I guess I'm saying I like the idea of the pedestrian neighborhood corner store. But when you add cars to it, I think at a very busy intersection, I think we're asking for trouble.
Yeah, I have like 8 convenience store right now and same type of locations.
Well,
so
obviously,
never happen.
Good. Well, I wish you luck. I mean, I hope it works out that way. Thank you.
I have not been sworn in.
Okay.
Raise your right hand. You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so.
I do. My name is Marilyn Kelly Cavada, same as Annalisa's, KELLY-CAVOTTA. I live at 12 West Elizabeth Avenue, directly across the street. My question for you is, and again, this is all going to be pretty much regarding the parking. How do you anticipate enforcing the parking? So we've talked about that you have adequate space, that you're going to have it a one-way. I have lived across the street from that establishment for over 25 years. And I have seen cars, the previous owners have tried to control the traffic, the directions in which they come in by using the same thing, using one entrance for coming in and one for exiting. They have tried to limit the parking for their occupants only. However, there are people who we have established that Carl's Corner is also on that corner.
Just, I don't mean to cut you off. You did ask him a question.
Okay.
You just need to let him answer the question.
Okay.
Which is, how do you propose to control it?
Yeah, just put a sign as much I can.
How are you going to enforce that?
Like I put maximum signs. So
the signs, and I come in and I park the opposite direction.
yeah, but I will tell like people is not like people know where the signage.
Okay.
So they have red lights, so people see red light, they don't cross. So mostly people follow.
I just want to give you a fair. I have lived there for over 25 years. They have had signs. People from Fratelli's park in that parking spot and take up their parking spaces. So of your 6 parking spots, you're now down to maybe 3. You have an employee who is going to work there. Maybe you're down to 2. There are going to be people who will park.
And we got
question.
Yeah. I feel like you're going through a lot of hypotheticals.
Oh, they're not hypothetical. I have the camera footage to back it up.
Okay.
And I give it to the police
This
every
is
time
for-
they come for an accident.
This is for questions.
Okay. How do you propose enforcing that you keep occupants from other establishments from parking in your parking lot?
Yeah, I will call the tow truck to tow them.
Okay.
Like only parking is for customer only. Our customer only.
Okay. Thank you.
Yeah, simple.
I didn't swear in either.
Raise your right hand. Did you swear that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes?
Yes. I got one question.
Your name? please?
Name and address.
My name is Robert McLaren, McClarin. I live at 1221 Lorraine Avenue. So I have a question. When you were disclosing what the convenience store was going to be about, you said welfare, it's going to be a convenience store, milk, eggs. I want to ask you this right now. why didn't you disclose the fact that you're going to be probably selling vapes at this place? We are dealing with a national crisis, and it's literally on every corner of Bethlehem. I see a new place selling vapes off the welfare of kids. And I want to ask this right now, will you be selling vapes at that convenience store? Can you answer that?
Okay, I have a 8 store right now, and all same rule applies. We don't sell vapes or cigarette tobacco to the minors. So I have like 20 years, not even one incident. So we strictly enforce, we check the ID. We don't sell tobacco product to the minors.
And so all of your other stores are making, probably that's where you're making most of your profit,
No.
off selling vapes and tobacco at all of your other 20 locations. Is that
Correct.
correct?
8 locations, yeah.
Okay. This is a neighborhood. This is a true neighborhood. And I hope the board recognizes this. Lorraine Avenue, we're the only ones that have block parties, right? I don't want to go into all this. I have 3 kids, 2 daughters and a boy in 7th grade. Both my kids go to Liberty. One goes to Northeast, right? And I see every day, and I deal with kids all across this Bethlehem that are dealing with these problems, right? And as they go and as they progress into adulthood and college students now, it's going to be so easy for them just to go up to your store and get addicted to something that they don't need while we continue to battle mental health crises in this world. I hope we consider this, that if it's a true convenience store, like when I grew up on 8th Avenue and we had what's called a corner store, that's what this thing should be about. We shouldn't be about doing this. So anyways, thank you for answering my question. I just wanted to let you know, why didn't you disclose that? I wanted to ask, why didn't you disclose that up front in front of everybody here? Okay? Thanks.
I think he did answer that, in all honesty. Yeah, yeah.
Did say the-
No, and then someone asked
Tobacco
vapes.
vape,
and he
whatever,
indicated
like
anything
state
illegal.
give me permission, I put it.
That-
I didn't
that's-
put anything else
That's
without.
what I thought he
yeah.
said, but just to
They have
clarify,
inspectors,
so I
they
didn't
check,
mishear.
they check like all over, so.
2 additional sort of process questions for you. I'm sorry. Sorry. Here are 2 quick ones. These will be,
Mhm.
how do you plan to do snow removal?
Yeah.
Because we do have a problem on that in the whole area with snow removal and it's especially felt in the alley. The previous tenants were, the previous owners were very good most of the time about removing the snow. They would have, a truck come in and they would take their, I guess, a backhoe and put it in there. Would you do something similar? Because there's no place to push it.
Okay, we will do something because we have contract with the snow companies. They will do all my other locations.
Okay.
So never problem.
So there's no problem, oh, I'm sorry, blocking a street, let's say, or blocking Radley.
No, they don't block.
Okay. And one other quick question, my neighbor Brian just pointed out to me. On the plan, there is in the corner a little, it says crossing.
Yeah.
It's on the corner of Radley and Elizabeth. That's kind of a problem zone. You'd have to go, right there.
Over.
Yeah, and
It says,
It's a word for apron.
oh, okay, it says crossover, which
What
is
does
a
that
word.
mean?
Hey, Mr. Taylor.
It's a word for apron, the depressed curb.
Yeah.
Okay,
Yeah.
so that's
And that's
not gonna
existing.
be the entrance.
No.
That's exist.
I think
No, this one intense.
so. Just on
This
Elizabeth,
one?
that's the only entrance.
Yeah, or a fence.
Yeah, I think
We-
Yeah, mostly.
Yeah. You're not proposing
And
to
then
come
I
in
go
off the
to
alley.
and turn left. So
or entering at a
What's the
zip-in
architect put
angle because people come up that alley and go,
so only one, right?
be pretty disastrous.
Yeah.
Yeah.
I will check by the architect.
Are you asking that the board consider a condition to have that crossover closed?
Yeah.
So the entrance has to be off the street? Is
Yeah,
that what I'm getting?
exactly,
Okay.
Exactly. In other words, that would also
that's the
take a lot of the question marks out of use of the alley. If you close that off, it would certainly, it would cut down on illegal traffic or, just
If the-
possibility of accidents at that
Yeah,
spot.
just so everybody realizes, the board can decide whether to attach that condition, but ultimately, city engineering department has to tell us
Oh,
whether
sure,
they're allowed.
sure.
They make the rules in that regard. We don't.
Sure.
Okay.
And that's no problem. My main concern is just, if you're prepared for making those entrances and exits really clear, that would be very helpful.
Yep.
Also,
Sure.
the snow removal.
Yep.
That's good.
Okay.
Thank you.
Thanks.
Just one last comment. I apologize. I was not sworn in yet. My name is Chris Rad, R-A-A-D.
You do swear or affirm the testimony which you shall give in the matter now before this, raise your right hand. Matter before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear?
I do. Just a brief comment. I know we're all here very late. I'm the realtor for the property. We had a myriad of different ideas and uses that we over the last couple months there. We had felt that this was probably one of the better ideas for the property. I had different ideas. I had a national pizza chain looking at coming in here. I had a couple different other daycares, different things. The building is limited just in its square footage. We just felt that this would kind of be in keeping with current traffic flows and current statuses for how the property currently is. So we just thought this would probably be a similar type lateral move with people coming in and out of the property like that. So we just thought that this would probably be a similar type of impact, and the owners are fully on board with trying to keep the community and keep the neighborhood intact the way it is, because they've been there for quite a while. But we just thought that this was one of the better uses that we have seen over the last couple of months with different prospects that we've had that would have been interested in coming into to the city here. So that's all. Thank you.
Thanks.
This is still during the questions. One last shot for questions, and then we'll move to final comment.
Okay.
Catherine Grasso again. What plans do you have for signage for, like, with your store name? Where would it be located? How big?
Same, they have a saloon one. I just replace.
Okay, so nothing on
Nothing.
this. Okay, thanks.
All right.
Any other
Comments?
witnesses?
No.
Okay.
Comments?
Although I guess we will say, we let you do a lot of commenting during the questions. You don't have to repeat yourself. No offense. Yeah, you can give comments. I'm just saying, don't repeat yourself. If you'd like to propose, yeah. Yep, go ahead.
Is it within my, to ask that a traffic study be done at that intersection? Is that something that I can ask the,
All the board can do is attach a condition that the city engineer has to review.
Okay.
Correct?
Yeah.
And he'll look at the parking spaces, the proposed one-way, the closure of the curb cut. That's about the extent of what the board can do, because there probably isn't sufficient warrants to require a full traffic study for a project like this.
Okay.
But we can ask that the city engineer review the layout and the access.
okay,
And the city engineer will do that, correct?
Yes.
Okay.
as part of that,
Mhm.
is, can you go and review the history of, number of accidents at that intersection?
I'm not sure what the engineer is going to.
But yeah.
Okay,
The extent of what the board can do is put a condition that the access and configuration of the parking lot be reviewed by the city engineer.
okay,
It's the city engineer. No one here has the capability
Yeah.
of doing it. I mean,
yeah, no, that's understood. Yeah,
Yeah.
I just didn't know if, what we're allowed to ask to do, but
Yeah.
I think though, having some of those answers for those of us who live in there and we see that traffic and we know, the foot traffic that goes through there, that might set our minds at ease one way or another if we had more information. Thank you.
Annalisa again.
Mhm.
I just, I have a wish list, if that's okay for the board, since we're on this. Is it possible to get permit parking for the people that are on Elizabeth? So then this way we,
We have no control over that. That's, who reviews something like that?
That would be through the parking authority.
so we just go through them. Okay. Yeah,
Yeah.
we're gonna need it.
Yeah. Yeah. There is a limit to the board's power.
Can we sprinkle water on you?
I echo the earlier sentiments that a corner store is a nice idea. So I just want to reiterate my request or recommendation that the consideration of tobacco products not be included in the sale of products at the store be considered, because I think that would be a nice feature to make it not the kind of vape shop concern that people have. I also echo the concerns about traffic, especially not just the one-way traffic, but the way that traffic might back up of people having to make that sharp turn. So just echoing the concerns about having someone really examine that just to double check.
Okay. All right.
All right.
We'll close the record and
We'll move,
discuss this.
go off the record and we'll be back.